So we're on the record in docket 25-02448. That is people of the state of Michigan versus Savannah Kinney. Appearances for the record, Ms. Fortuna Gill.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Mr. Austin.
Thank you, Your Honor. Good morning. Jared Austin appearing on behalf of Ms. Kinney. She stands present to my right.
And ma'am, you are Savannah Kinney, is that correct?
Correct.
Thank you. This is the time set for a probable cause hearing. Ms. Fortuna Gill, how we proceed?
Your Honor, at this time, I do believe that the intention is to leave this set for preliminary examination. I'll defer to defense counsel.
And is that a fair statement, Mr. Austin?
That is correct, Your Honor. Pending offer has been made. This time we will consider that, and we would just ask that the matter be left on as scheduled for the preliminary hearing next week.
All right, this is scheduled for October 24th at 8:30. And we'll leave on for the preliminary examination. Anything else for that'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in docket 25-02448, Ms. Fortuna Gill?
Nothing, Your Honor.
Mr. Austin.
Yes, Your Honor. Briefly, a matter of bond, if I may.
Sure.
Ms. Kinney informs me that she has a pre-planned weekend trip set to begin on the night of the 24th. It would not interfere with her attending court, but she's had a pre-planned weekend trip to Florida, which obviously her bond conditions limit her to interstate travel unless given permission by the court. I would ask if the court would grant her a variance for that trip. I would note that, Ms. Kinney is here. She's reporting to pretrial services. As far as I can tell, she has absolutely no prior criminal history.
All right, thank you. What is the purpose of the pre-planned trip to Florida?
I think it's just a weekend, just a brief vacation, I believe, Your Honor.
Okay, and when does Ms. Kinney plan? Ms. Kinney is because this is a 10-year felony. She'd be leaving the night of October 24th.
I believe so, Your Honor, which would be Friday, and I think returning that Sunday. Is that correct?
Correct.
I would also note, if the court has any concerns as well, Your Honor, she's well grounded in the community. She's working multiple jobs. She has a young child here, so I think that would help reduce any concerns the court may have as it relates to flight.
All right. The bond was previously set at PR bond by the arraigning magistrate. Any objection to a modification of bond, Ms. Fortuna Gill?
No, Your Honor, the people would leave it to the court's discretion.
Okay, there's presently a no contact order with the typical conditions. I'll modify the bond that the defendant can leave the state from Friday, October 24th to Sunday, October 26th. And then anything outside that has to be as part of bond conditions, no out-of-state travel. But the modification, that would be that's a Florida trip. Is that correct, ma'am?
Sir.
And what airline are you flying to Florida? Or are you driving there?
Not driving.
Okay.
Spirit.
That's Spirit. All right. People have been known to drive to Florida, but it's not an easy drive, okay? Especially over 2 days. All right, so we'll modify bond to leave for the defendant to leave October 24th and to get back October 26th to Florida and then the flight is by Spirit Airline. Anything else for the record in 25-02-448? We've left this on for prelim for October 24th at 8:30. Ms. Fortuna Gill.
Nothing for the people,
Mr. Austin.
I have nothing additional about Ms. Kinney at this time, Your Honor.
All right, Ms. Kinney, we'll see you next week on October 24th. Thank you for your appearance. We had. What's the next?
Bynum. I think.
Bynum. Mario Bynum.
He's on Zoom. I think he's at work.
All right. All right, Mr. Bynum, we'll call your case. You can unmute. So we're on the record in docket 25-02562. That is People of the State of Michigan versus Mario Bynum. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Palmer.
Robert Palmer, the Public Defender's Office, on behalf of Mario Bynum, who appears today via Zoom.
And sir, you are Mario Bynum, is that correct?
Yes, sir, it is.
And you can hear me all right, Mr. Bynum?
Yes, sir, I can hear you.
All right, thank you. This is time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, I believe that the plan is to leave this up for preliminary examination. At this time, I'll defer to defense counsel.
Mr. Palmer.
That's an accurate statement, Your Honor. We intend to leave the matter set for preliminary examination next week. Mr. Bynum and I have been in good contact. I don't have any issues with that. I have every reason to believe he'll appear next week. We're leaving the matter set.
All right, Mr. Bynum, we're leaving on the probable preliminary examination for October 24th at 8:30. That'll be live in person on the 6th floor of City Hall of Lansing. All right, Mr. Bynum?
Yes, sir, understood.
All right, anything else for the record in docket 25-02562, Ms. Fortuna Gill?
Nothing on behalf of the people.
Mr. Palmer?
No, Your Honor, thank you.
All right, Mr. Bynum, you're all set. Thank you for your appearance today.
Thank you. Have a good day.
You too.
For Judge Ward's docket, I believe we're waiting for Mr. Goodrich to return, but we can handle Lopez. I don't believe there's an attorney assigned.
All right, is Jimmy Lopez here?
If that's what I was gonna ask, I don't know if that is a Polycom or
All
something
right.
on Zoom.
Let's see, we have identified. Is anybody on the Zoom court hearing a Jimmy Lopez or representative for Jimmy Lopez? All right. So I don't see Jimmy Lopez or representative, and he's not represented by counsel today, is he?
I don't have an appearance and I didn't see one in jail.
Let's put that on the record, and then I'm assuming we'll just leave it on for right now.
Well, I'm a little concerned if
Whether
maybe
he's-
hold off and see if he's
Well,
going to appear.
It's Judge Ward's docket, and I hate to bench warrant him. We can bench warrant him.
I don't know if we want to.
Staff members up north.
So that's what I'm afraid of is he went to Judge Ward's
Oh, I see what you're saying. Yeah.
Zoom courtroom, and nobody's monitoring it, and then he doesn't get transferred, and so
Maybe.
and so maybe it's our fault.
Yeah, I see what you're saying.
So so let's put Mr. Lopez aside to see if he shows up
Yeah.
later.
That's
Okay,
probably better.
all right. We can always ask. I don't think anybody's
Yes.
monitoring that.
Okay.
All right. Miss Fortuna Gill, how about anything else?
We're ready on Abu Alami.
That's Miss Wanji and Miss Ryan.
Mr. Austin's filling in for Miss Wanji.
All right, and
Filling in on both of Ms. Wanji's case.
all right.
It's like post 2, visit room 6. That looks
All
like
right.
him.
All right, we'll call Mr. Alami's case. That's our docket. That's so we're on the record in docket 25-03011. That is People of the State of Michigan versus Abu Alami. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Austin, you're covering for Ms. Wanji.
Yes, Your Honor, that is correct. Filling in for counsel of record, Ms. Wanji, appearing today on behalf of Mr. Alame. He is present remotely from the Ingham County Jail.
And sir, you are Abu Alami, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Alami?
Yes, sir.
All right, thank you. All right. This is the time set for a probable cause conference. Ms. Fortuna Gill, how we proceed?
Good morning, Your Honor. I do believe that at this time, we're leaving the matter set for preliminary examination. The people did extend an offer to defense counsel, and I believe they just need some more time to consider that. But at this time, leaving it set for preliminary exam, I'll defer to defense counsel.
Mr. Austin, is that a fair statement? We're leaving this on for a preliminary examination.
That is correct, Your Honor. An offer was extended. I'll use the opportunity between now and next week to discuss that with Mr. Alame, but at this time, we would just ask the matter continue on as scheduled.
I don't have a time, 9 a.m. All right, Mr. Alame, we've left the preliminary examination on for October 24th at 9 a.m. If you have any questions, you can speak with your attorney, Ms. Wanji, next week. Anything else for the record in 2503011, Ms. Fortuna Gill?
Nothing on behalf of the people.
Mr. Austin.
Your Honor, Mr. Alame asked if I could address bond with the court.
I can review bond, Mr. Austin, when you're ready.
Yes, Your Honor, thank you. I know it would appear on its face that it seemed to be reasonably set, and I can certainly understand that. However, I think it's still set in a matter that Mr. Alame would not be able to post. What I can say is it appears that he has very limited criminal history. I think he's under supervision with another court. There's a matter that is non-public. So given that, Your Honor, I would ask the court to consider granting him some type of relief, either in the form of the amount of his bond. From speaking with him, yeah, he reports to me that he does not have a history of failing to appear in court.
All right, thank you. Let's see. Response, Ms. Fortuna Gill.
The people will leave it to the court's discretion, Your Honor.
The bond was set by the magistrate at 4,010%. And I'm certainly not going to question why she set the bond at 4,010%. There is a do not be on specific premises. We can revisit this at preliminary examination, but I'm going to deny the modification of bond. And then we can bring it back up at preliminary examination. Anything else for the record on 2503011, Ms. Fortuna Gill?
Not for the people.
Mr. Austin?
Nothing additional, Your Honor. Thank you.
All right, Mr. Alami, we'll see you back here on October 24th at 9 a.m. You should be all set, sir.
Your Honor, I got a question real quick. Can I say something?
You probably shouldn't, at the request of your attorney.
It's just about the bond. So am I able to be able to bond out today? Like if I pay or
not today, sir. But your bond is set at 4,010%.
If you can post the bond, yes.
Yeah.
I paid 4,010%, I'll be able to get out.
Yes, at 4,010%, that's what bond's posted at.
Okay, thank you, sir. That's all.
Thank you.
Sure.
Yeah. All right, so we're on the record in docket 2502704. That's people of the state of Michigan versus Brandon Brown. Appearances for the record.
Your Honor, there's two Browns on the docket today. We're doing Robert.
Robert Lee Brown.
Yeah, there are two Browns.
Yeah,
Okay.
it's a headache.
Okay, let's do Robert Brown. All right, so we're on the record in docket 2503015. That's people of the state of Michigan versus Robert Brown. Appearances for the record, Ms. Fortuna Gill.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Mr. Austin.
And thank you, Your Honor. Jared Austin appearing on behalf of Mr. Robert Brown. He is present from the Ingham County Jail, appearing remotely.
And sir, you are Robert Brown, is that correct?
Yes.
And
Can you hear me? Hello?
oh, there you are. Okay.
Yeah.
And you can hear me all right, Mr. Brown?
Yes, I can.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, I believe the intention is to leave this set for preliminary examination. I will defer to defense counsel.
All right, Mr. Austin, is that a fair statement?
Yes, it is.
All right, we'll leave on for preliminary examination previously set on October 24th at 9 a.m. That'll be live on the 6th floor City Hall of Lansing. Anything else for the record in docket 2503015, Ms. Fortuna Gill?
Not for the people.
Anything else, Mr. Austin?
Nothing additional on behalf of Mr. Brown at this time, Your Honor.
All right, Mr. Brown, you're all set. We'll see you next week on October 24th at 9 a.m. Thank you for your appearance today.
Thank you.
And while we have Mr. Austin, if we could do Eccles, and then I will
Then we
pass
can-
it over to Cass. Yeah. Mr. Cheeks.
It's fine, no, say it anyways.
Kachukas. Is that right?
Yeah.
All right.
Yeah.
Yeah, there we go.
All right. I got lucky, I think. All right, so we're on the record in docket 2503013. That is people of the state of Michigan versus Nehemiah Eccles. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Austin.
And thank you, Your Honor. Jared Austin appearing on behalf of Mr. Eccles, filling in for counsel of record, Ms. Wanji. Mr. Eccles appears remotely from the Ingham County.
And sir, you are Nehemiah Eccles, is that correct? Is there a Nehemiah Eccles?
On the top
Okay.
right.
And so, sir, if you move closer to the microphone, you are Nehemiah Eccles? For some reason, we're not getting any audio. Post 1314. Is that him, Mr. Austin?
Yes.
All right. And sir, you're raising your hand. You are Nehemiah Eccles, is that correct? All right. And you can hear me all right, Mr. Eccles? All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, I believe the intention is to leave this set for preliminary examination. I will defer to defense counsel.
Mr. Austin, is that a fair statement?
That is accurate as it relates to the preliminary hearing.
All right. All right, we'll leave on for preliminary examination on October 24th at 9 a.m. as previously scheduled. So, Mr. Eccles, that will be on the 6th floor of City Hall of Lansing on October 24th at 9 a.m. All right, sir? All right. Anything else for the record in 25, for the record, Mr. Eccles is waving his hand so he understands. Anything else for the record in 2503013, Ms. Fortuna Gill?
Not for the people.
Mr. Austin,
Your Honor, Mr. Eccles did ask if I could address bond, if I may.
you may.
Yes, thank you, Your Honor. It's presently set in a matter that Mr. Eccles cannot afford to post. Positively speaking on Mr. Eccles' behalf, my review of his criminal history, it shows that the last conviction he had of any kind appears to be about 8 years ago. He purports to me that he does not have a history of failing to appear in court. Upon release, he would be living with his mother in another county. It would not interfere with him participating in any court hearings. But it also, I think, would provide additional assurances to the court that there wouldn't be any issues with him as it relates to the no contact order. He was working prior to his incarceration. So I would ask the court to take that into consideration and consider granting him some relief, either in the form or in the amount of his bond.
All right, thank you. Ms. Fortuna Gill, any response from the people on the modification of bond?
Your Honor, the people would like to bring it to the court's attention, the violent nature of the crimes that are charged. Additionally, these are charged as a hab third. Mr. Eccles does have quite the assaultive history. So the people would like to bring that to the court's attention, but leave it to your discretion.
All right, the bond was set by the magistrate at 75,000 cash surety. They're all assaultive crimes, and this is a third offense notice, previously convicted of child abuse in the second degree and a home invasion first. I'm going to deny the modification of bond. And this can be revisited at preliminary examination. So, Mr. Eccles, I'm denying the modification of bond. We'll see you on October 24th at 9 o'clock. Anything else for the record in 2503013, Ms. Fortuna Gill?
Not for the people.
Mr. Austin?
No, Your Honor, thank you.
All right, Mr. Eccles, thank you for your appearance today. You should be all set.
Thank you, Judge.
Thank you, Mr. Austin. Now, Ms. Kachukas.
Yes, Your Honor. I know we're skipping down the dock a bit, but
That's
I was
okay.
hoping we could handle Marcelo Luna. It'll make sense as we go on the record.
You have an interpreter for that case, Judge.
Well, I'm not sure the interpreter will be necessary.
Yeah.
We'll find out in a moment.
I tend to speak gibberish, but I don't know that they'll be able to interpret
One
that.
was requested, so
Yeah.
one was.
That is Marcelo Luna.
Yes. Yes. Well, we'll be necessary for prelim, but
And we do have an interpreter here, but minor, is this a fail to appear?
It's not
No.
a failure to appear, it's just where he appeared.
Okay.
And he appeared in ICE custody, apparently. He's at, I forget.
the Baldwin Center, I believe.
Yeah, I forget the name of it, but it's in Baldwin. It's the North Lake Correctional Facility. He's being held by ICE and communicating with Ms. Kasukis. Apparently, we've got to writ him here, or they've got to writ him here.
From
Yes.
Right, but
And-
whether they allow, or I guess we have, well, I'll let you talk.
Yes, it's my understanding that ICE is allowed to just deny the writ. I'm not sure with the reason. It just sounds like they can simply say they're not going to comply with the writ.
Was a writ done in this manner?
A writ was not done in this matter, but because even if we can get a successful writ, I think we may only be able to get it once.
Well, let's
So I don't know if
do the writ and see what happens. And then if they deny the writ, then
we were hoping if we could. It's going to take a little bit of time to writ the day, so we were hoping we could maybe get a prelim date scheduled for the 30th or 31st.
I haven't even talked to my client.
Yeah,
Your Honor.
so-
It's not.
you haven't talked to your client, he can't waive. We
Yeah,
can't get him here without a writ.
Right.
I think that's a good cause to adjourn
Yes.
a preliminary examination because we can't get the defendant here. So, first of all, let's do this. Let the interpreter leave because there's nobody to interpret for. So you're all set.
And I take it back about that date, Your Honor. Mr. Martinez has just informed me that we are going to need a date related. How long now?
How many days do you need, Mr. Martinez,
Your
for?
Honor, good morning. Joel Martinez on behalf of the people of the state of Michigan.
We haven't called the case yet. We're just yakking.
Yeah.
So I'm dealing with a similar situation in 54B with someone that's in the exact same ICE facility in Baldwin.
So you've got a better inclination of how long the writ's gonna take than I do.
Yeah, and I did prepare a writ in that case, and it took a lot of work to get them to approve it. I would say if Your Honor would be inclined to allow 30 to 45 days.
4 to
Judge,
6 weeks is fine. Yeah,
that'd be great.
yeah. So,
I can't say it's gonna matter to my client.
yeah, because we don't have the defendant here.
I know, I have a question.
Okay.
Traditionally, when we do a federal writ, anybody in federal custody, it may be different with ICE, we had to go through DOJ and the marshals. Are they requesting that on this?
No, because
Okay.
I have a contact at ICE that I've been working through.
Okay,
Not me personally, just I have
That's probably the
Professional.
better method.
a
Yeah.
professional contact.
Okay.
At ICE who I can use and I can circumvent all that.
perfect.
All
Okay,
right.
I know from the past, we had to back up and go through different hoops.
All right. So let's go ahead and call the case. and then we'll put it all in the record. So we're on the record in 25-03016. That's people of the state of Michigan versus Alicio Marcelo Luna. Appearances for the record. This is being called, this is a Judge Ward probable cause conference. Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the people.
Mr. Kaplan.
Your Honor, Jeffrey Kaplan, P74943, on behalf of the defendant who is not present.
All right. And my understanding is the defendant is in federal custody and has to be writ out. And we haven't done a writ yet because we're making sure we do it right the first time, or because he's in ICE custody, he's not in federal custody. Is that a fair statement?
That's a fair statement, Your Honor.
All right.
It's a little different of a system.
Right, and so it's a little different of a system. We need the defendant here. Mr. Kaplan has indicated he's had limited contact, if any, with Mr.
I've had no contact
with Mr. Luna. All right, and so let's go ahead. And I'm gonna find good cause to adjourn. Just knowing that we're going to take some time to set the preliminary examination. It won't be done in a week. We're not leaving this on. So I'll find good cause to adjourn. And
Your Honor, if we could set another PCC instead of another exam date.
I almost hate to use when we get him here for a PCC.
That's my concern as well.
Yeah, then we're gonna have to get him here again for the prelim, and that may create a problem.
And I don't know if we'll be able to get him here twice.
Yeah.
It'd take 4 to 6 weeks to get another writ for prelim. And then second, I don't know if we can get him here twice. Getting him here once is gonna be problematic as
All right.
So let's set for preliminary examination. And I think the parties all know the complications we have on the case. He'll be writ out of, so the defendant is to be writ out of ICE custody. We will need a Spanish interpreter is needed for this case. For preliminary examination. And then, so we'll need a Spanish interpreter who did show up today, but we'll need to order one for the next file, and we'll set that 4 to 6 weeks out for preliminary examination on. And I would err on the 6 weeks than the 4 weeks.
December 5th at 9.
December 5th at 9 o'clock, just to accommodate the writ and then the ICE detention, which we know is going to be a little different. Okay, so I find good cause to adjourn, mostly because we're just trying to get Mr. Marcelo Luna here so that we can start the preliminary examination process. Mr. Kaplan's here. Any objection to the good cause adjournment to December 5th at 9 o'clock, Ms. Fortuna Gill?
Ms. Kachukas.
Ms. Kachukas.
No objection, Your Honor.
I just learned Ms. Fortuna Gill, so now so that's why I just say it by rote now. Mr. Kaplan, any objection to the process so you can see your client?
No objection, Your Honor.
All right. We'll set a good cause adjournment for December 5th at 9 o'clock. Thank you for your appearance, everybody.
Thank you, Your Honor.
That's the Judge Ward. Mr. Goodrich is ready on Perez and Garza.
I'll take a look for him.
Oh,
so is that, I
or is
think
he on Zoom or?
Yeah, he's on Zoom.
Oh, there he is. Okay. And yes, I'm.
So let's go on Garza. That is Judge Ward's docket, 25-02237. All right, and then Mr. Goodrich, is Mr. Garza here today?
I am. He is at MRF Hearings 1.
All right,
Mr. Garza.
perfect. All right. All right, so we're on the record and 25 is 02237. Oh, we should do a motion too.
Yes, Mr. Martinez just reminded me.
So appearances for the record for the probable cause count, this is People versus Rogelio Garza III on 25-02237. Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the People appearing and requesting permission to practice pursuant to MCR 8.120 with Ms. Fortuna Gill and Mr. Well, Ms. Martinez is leaving now as my supervising attorneys.
All right. Granted, that's granted. You only have to make that one time, one per day. And then Mr. Goodrich, you're appearing on behalf of Mr. Garza.
That is correct, Your Honor. Yes. Attorney Luke Goodrich.
And then you are Rogelio Garza III, is that correct?
Yes, sir.
All right. And you can hear me all right, Mr. Garza?
Yes, I can. Yes, I can.
All right. Thank you. This is the time set for a preliminary probable cause conference. Ms. Kachukas, how are we proceeding, or would you like to defer to Mr. Goodrich?
Your Honor, I will defer to Mr. Goodrich ultimately, but I would like to state first that there will be an offer made on this matter. One has not been made yet because we are awaiting some additional information from law enforcement. Mr. Goodrich, I did get his email that he had just sent me a few moments ago regarding this case. I do anticipate that will be the offer, but I need to run it by supervising attorneys after I have that information.
All right. So Mr. Goodrich, I would assume you're leaving this on for a preliminary examination next week?
That is correct, Your Honor.
So we'll leave on for preliminary examination for October 24th at 8:30 in front of Judge Ward. And there will be an offer to come from the prosecutor's office. I'm assuming we're gonna writ him out for the prelim.
Yeah.
So is he gonna need more than that week? Is he just, that's what I was hoping, but I don't see a written. Oh, wait. I don't see a written, but I could be missing. I have video arraignment. I don't see. Appearance. A writ.
Okay.
For preliminary examination on October 24th. All right. So, Mr. Garza, we've left on preliminary examination for October 24th at 8:30. The writ was done and signed by myself, or signed by Judge Ward. So you will be writ out for the preliminary examination. Anything else in the record in 25-02237, Ms. Kachukas?
Not from the People, Your Honor.
Mr. Goodrich?
Nothing further, Your Honor. Thank you.
All right. You should be all set, Mr. Garza. Thank you for your appearance today.
All right, thank you.
And then let's go on. Mr. Goodrich, you had Mr. Calvert.
Ms.
Mr.
Calvert,
Terry.
I haven't spoken with yet, but I am ready on Mr. Perez. I still have to speak with Terry and Calvert.
All right. It's called Jordan Perez. And this is Judge Ward's.
Yes.
All right. All right, so we're on the record in docket 22-01839 on Judge Ward's docket. That is People of the State of Michigan versus Jordan Perez. Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the People.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Perez, who's appearing over Zoom today.
And sir, you are Jordan Perez, is that correct?
Yes.
And you can hear me all right, Mr. Perez?
Yes, sir.
All right, thank you. This is the time set for a probable cause conference. Ms. Kachukas, how are we proceeding?
Your Honor, the People have extended an offer to the defense this time. That would be a circuit court offer. That would be either a charge and cap in circuit court or a referral to 30th Circuit Court Mental Health Court. But I believe Mr. Goodrich may have I don't know if this is being left set for exam, however, so I will defer to.
All
Mr.
right.
Goodrich.
Mr. Goodrich, how are we proceeding today?
Well, Your Honor, it is the defense's intention at this point to file a petition for competency evaluation in this matter. I would probably recommend that we just leave the matter set for now,
Okay.
and then we will try to get that to Judge Ward early next week, and then that would adjourn the hearing indefinitely.
All right. All right, so we're gonna leave on at the probable cause conference for October 24th at 8:30 in front of Judge Ward, with the understanding some paperwork might be filed with Mr. Goodrich that would have something, some impact on that October 24th date. So that'll, Mr. Perez, that'll be live in person on the 6th floor of City Hall of Lansing in front of Judge Ward on October 24th at 8:30. All right, sir?
Yes, sir.
All right. Anything else for the record in 22-01-839, Ms. Kachukas?
Not for the people, Your Honor.
Mr. Goodrich?
No, Your Honor, thank you.
All right, Mr. Perez, you'll be in front of Judge Ward on October 24th at 8:30. Thank you for your appearance today.
Thank you. Oh, what's going on?
All right. So Mr. Goodrich, that's all Mr. Goodrich's cases for now, right?
I believe so.
Yes, if I could be placed in a breakout room with Mr. Terry, and then Ms. Calvert.
Okay, Mr.
He's in,
I
Mr.
can
Terry's
place you in a
post 2,
breakout.
is at 5.
Post 2. All right. So let's place you in, you can go back to room 2 and then Megan will set it up so you can be with your client. It's Mr. Perry. Mr. Terry. In that room. All right, Ms. Fortuna Gill, how are we proceeding?
The people are already on Vaughan.
All right, this is on our docket. 250304.
I'm here. I'm not sure how to unmute my mic, but as long as I have this talking button pressed, you guys can hear me.
All right, Ms. Vaughanauer, you're here and we're going to hold your PCC, your probable cause conference. So you can unmute and you are unmuted. We're going to call your case next. All right, ma'am?
Can you hear me?
We can.
Okay.
All right, so we're on the record in docket 2503047. That is people of the state of Michigan versus Jane Vaughanauer. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Ms. Vogenauer, who appears today via Zoom.
And ma'am, you are Jane Vogenauer, is that correct?
Yes, Your Honor.
All right, you can hear me all right, Ms. Vogenauer?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, I believe the intention is to leave the matter set for preliminary examination. I will defer to defense counsel.
Is that a fair statement, Mr. Palmer?
That is, Your Honor. Could I have just 1 quick second to talk to the prosecutor?
Absolutely.
Sorry.
Yeah. That's okay. I appreciate the heads up.
Yes, Judge, I just need to address one very quick, I guess, bond issue, if I could. My client is wearing a GPS tether as an order of this court currently, as I understand it. And my concern is that both this and, more importantly, the 30th Circuit Court are within the exclusion zone, I believe. She's actually, as a result of this case, there is now a PPO against my client. She's required to attend a hearing today at 11 o'clock at the 30th Circuit. This incident is alleged to have happened essentially right across the street from 30th Circuit. And the problem is she's going to be in this condition where her appearing for court next week for the preliminary exam or in an hour and a half for her 30th Circuit hearing, both of those are going to violate her exclusion zone tether.
So the exclusion zone is a zone of mileage, and this court and the family court are in the zone.
That's what my understanding is. Essentially happened at the apartments directly across the street on Kalamazoo from the 30th Circuit Court. And so I quite honestly, Judge, I don't know how to fashion it with the GPS tether in place.
Yeah, I can modify the bond that any for this court, but she's still going to have to go to the family court and have them modify whatever bond they have. My bond modification would be that she's exempt for attending any criminal cases, any of this for 2503047.
And that's what I'm asking. I think what I'm saying is that the tether that's attached in this case prevents her from going to the 30th Circuit. So even it's not really a 30th Circuit court's order. It's this case court's order. It just prevents her from going to that courthouse.
So I'll modify the bond to allow her to go to court, either 54A or 55th district, or what circuit court is that?
30th.
Is that 30th Circuit? 30th Circuit Court. What she's going to do though, she's going to have proof that she has required to go to court. Because if she stops, she'll have to say like, I got to be here. This is, and so either a notice or something along those lines.
Right, and she does, based on my conversations with her, she does have the notice for court. We were discussing that yesterday. It's just that, as I say, she's required to be there today at 11. And you know, their suggestion was we'll call JSG, and JSG's answer basically is we're not changing anything without an order of the court.
Right. So, and that's been my experience is they set up to modify the zone, and this has happened before. The zone includes the courts. So we just modify to have the courts exempt as long as there's proof that they have to go to court that day.
Right. And what I am imagining is that in about an hour and a half, there's going to be some scenario where she's sitting in Judge McCormick's courtroom with the tether siren blasting, which would be fun for everyone.
Yeah, that's exactly what I was worried about. The pretrial people didn't answer me when I called the tether people, so I just was able to leave a voicemail, and I don't want it like blaring. But also, I had a question because the judge at the veterans courthouse said that I'm allowed to go wherever, even back to my apartment. So there's like two contradictory bail conditions from two separate judges.
Yeah. That the bureaucracy of the court system versus the bureaucracy of the private company that places you on. What I'm going to do, and it will not be, but it will be in the computer, I would think. I'm going to modify the bond. So as long as you're attending the family, as long as you have a reason to attend a court date, we'll modify the bond. That'll be placed in the computer. But that's not, so that should take care of the problem tomorrow. Yeah. Today, you're gonna have to figure out. You're probably going to have to put up with the tether going off and family court, because I don't know. We'll send them an email. We can send GPS. Okay. And so we just sent them an email saying. Yeah, and we just sent them an email from the court saying that you're exempted from attending any circuit court. So we told them about that hearing at 11 o'clock. Somebody's got to read it, do something about it, but we emailed it from
because I do have a list scheduled to be there this morning. So
okay, all right.
Oh, go ahead.
I tried to contact the court myself yesterday to advise them of this issue and was not able to reach anyone.
This has not been the first time that this has come up, because they just do a zone, and we just happen to be in the zone.
Sure.
All right. So we've emailed the private agency that's involved, but it may go off because they've got to read it and then react to it.
Okay, I just had a question too, because they scheduled me another court date in person the same date and time as my second one with this courthouse with you guys on the 24th. One or the other.
That's a family court case. That's in front of Judge McCormick.
Yeah, but so today's was at around the same time, same date, and so is the 24th for both of you guys. Yeah,
I would let Mr. Palmer knows that. you may not have a second hearing on the PPO if it's has to do with this.
The part of the problem, Judge, because it's a PPO issue, it doesn't appear, the schedule doesn't appear on their public, I can't search it.
Right.
I know she's got it at 11 o'clock today. I did not know she has another one at the same time as the exam next week. I'll certainly look into the issue and I can contact the court. I get this court, I guess, if that's going to, if we're going to have a conflict, and
we can set it a different time on that date.
Right. Maybe we can have a waiver timeline or appear via Zoom or something.
Okay.
Well, I will make a note and I'll try to figure it out.
All right. And then,
sorry, I just had a question just because you might remember me because I used to come into your courtroom for a case of domestic violence with Joseph Oakwood. I have 2 small children I have full custody of with special needs that are 2 and 3 years old. And last time the father of my children violated, I was asked not to bring my children with me. So if we could do Zoom, just because my daughter stims a lot, she's severely autistic, that would be ideal. I don't want
I'm going to wait to hear from Mr. Palmer on whether on the Zoom, whether we need Zoom, because at a preliminary examination, this is set for preliminary examination, that if you have the prelim, that's an adversarial setting. And I don't want to, I don't want, that has to be by preliminary examination. That has to be, that can't be via Zoom.
What does adversarial mean? I'm sorry. I just not
that
sure.
means that means the people of the state of Michigan are enforcing their charges against you.
Okay.
And in a criminal case, it's not allowed to be via Zoom, only in a civil case.
Would it be okay if I did bring my children to this, if it's in person?
Talk to Mr. Palmer and he can answer any questions you have.
Okay. Okay. Thank you, Judge.
All right. So we'll leave on for October 24th at 8:30. Ms. Vonnegut, thank you for your appearance today.
Thank you.
Thank you, Judge.
And that's our file. So this is our file on the record in docket 25-03049. That is people of the state of Michigan versus Kadena Jackson. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Doyle.
Good morning, Your Honor. Dan Doyle on behalf of Ms. Jackson, who is appearing from the Lincoln County Jail.
And ma'am, you are Kadena Jackson, is that correct?
Absolutely, yes, I am.
All right, and you can hear me all right, Ms. Jackson?
Yes, I can.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, the people have extended the offer of attempt restricting and obstructing with that would be an amended count 1. I do believe that defense counsel intends to leave this set for exam. I will defer to Mr. Doyle.
Mr. Doyle.
Yes, Your Honor, that's an accurate statement. We want to leave this set for exam for next week.
All right, we'll leave on for preliminary examination for October 24th at 9:30. That'll be live in person on the 6th floor City Hall of Lansing. Anything else for the record in 25-03049, Ms. Fortuna Gill?
Not for the people.
Mr. Doyle.
Yes, Your Honor. I did want to address bond on this matter.
You may proceed.
Yes, Your Honor. The bond is currently set at 2,000, 10%. Although my client is employed, she can't afford that bond at this time. And one of the other reasons is that we want her to keep her housing situation. She's currently living in a transitional housing for women and children. And so she's here in county. She won't be able to make any and all court proceedings. I would say for the record that there is an additional hold for $250 out of Clinton County. So it's mainly the financial issue.
Okay. Response, Ms. Fortuna Gill. I have a pretrial report that the arraigning judge got to see.
Your Honor, the people will leave it to the court's discretion.
All right. I have from pretrial services indicating that the defendant has 2 or more prior qualifying failed to appears, and that the court set bond with that. The interview was not completed. This is an RO, and then the court has a pending, and that's what you're talking about, or is that the MDO, the malicious destruction of building is a pending charge out of 14B district court? Were you aware of that?
No, I'm not aware of that.
So the bond was set based on the malicious destruction of building pending case out of 2024. And then 2 or more failed to appear entries. So I'm going to keep bond as is at 2,010%. That was set by the arraigning judge. Looks like Judge Ward sent it. Anything else for the record? So I deny the motion to modify bond based on the pretrial report. Anything else for the record in 25-03049, Ms. Fortuna Gill?
Not for the people.
Mr. Doyle?
No, Your Honor, thank you.
All right, Ms. Jackson, we'll see you on October 24th at 9:30. You should be all set, ma'am.
Thank you.
Then who did you have?
McGuire.
That's a sentence.
Yes, Your Honor.
I put those aside. I was gonna get so organized. And now I can't find anything. All right, so we're on the record in docket 18-02663. That is People of the State of Michigan versus Antoine Marshall McGuire. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Lee.
Thank you, Your Honor. Assistant Public Defender John Lee on behalf of Antoine Marshall McGuire.
All right, this is the time set for sentencing in the matter. Ms. Fortuna Gill, is there any further restitution in this matter that the people are requesting? I have no restitution in this matter, or LPD, or minimum costs.
That is correct, Your Honor. There's no further restitution.
All right. Mr. Levy, you had the opportunity to go through the pre-sentence report with your client.
I have, Your Honor.
Any additions, deletions, or corrections?
Only one correction, Your Honor. The report lists his employer as Chili's part-time. He is in fact now working full-time at West Rock Manufacturing.
All right, with that correction concerning the full-time employment, anything else, Mr. Lee?
Nothing further, thank you.
All right, allocution, Mr. Lee.
Thank you, Your Honor. Mr. McGuire has participated and taken responsibility in this case. He has been working with probation and is working with Crystal Ray to get the substance use assessment completed that they are requesting. He had some insurance snafus, which is why it hasn't happened yet, but he's got that worked out, and that is going to happen, which is important because Mr. McGuire is a father of 5 children. They all live here in the Lansing area. He pays child support. He's involved in their lives. And with this new full-time job, he looks forward to participating in any sort of substance abuse programming that the report calls for, because he wants to set an example and provide for his children.
Right, thank you. Ms. Fortuna Gill, anything on the sentencing before I hear from Mr. McGuire on this file?
No, Your Honor, the people leave it to the court's discretion.
Mr. McGuire, anything you'd like to say to the court before the court passes sentence?
No.
Thank you. This is for a guilty plea on August 28, 2025. It's a use of controlled substance. I'm going to follow the recommendation. Seems to be based on a rehabilitation in regards to drug use. So we'll have the defendant spend 6 days in jail, credits given for 6 days previously served. I'm going to suspend the remaining 45 days upon successful completion of probation. So we'll set fines and costs at $200 fines, $200 costs, crime victims' rights fee of $75, state minimum court cost fee of $50, and then $30 a month for probation for 6 months. And I'll give you a full total of that. So that'd be $705. Probation for 6 months via Zoom. The 7411 is granted. That's kind of the carrot here. That's abstracted in a different way. So if you're able to go through this, complete probation, it's abstracted in a way that's not seeable by others who may want to hire you or something along those lines. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance without prescription. Submit to random PBTs. Enter urinalysis as directed, and no bars or nightclubs. Mr. McGuire, usually people violate probation because they end up what we call dropping dirty, okay? So if that's not an application to you, this is your chance to shine, okay? If not, I don't know you, you don't know me, then if you start to drop dirty, then we see what resources are available to help you get through this period, okay? To see if you have a destructive relationship with drugs and alcohol. District court doesn't help everybody, but we do have the resources to help some, all right? All right, so we'll complete the following rehabilitative services, pay fees, and provide proof of completion of the court. Substance abuse assessment and follow recommendations set by the probation officer. Your probation officer will be Joseph Sumter. Mr. Sumter is a pretty flexible guy, pretty easy to get along with. Not purchase or possess firearms, ammunition, or weapons of any kind, and obtain and maintain employment as you're doing now. This will be a reportable conviction to the Secretary of State. Anything, do you have any questions of me concerning the judgment of sentence, Mr. Lee?
No, thank you, Your Honor.
Any questions of me concerning judgment of sentence, Mr. McGuire? All right, I would go down to the 5th floor just so you know who to contact and how to contact Mr. Sumter. He would be the one to violate you. So just make sure you're on the same page as far as the Zoom goes. Okay, sir? Anything else for the record in 1802663, Ms. Fortuna Gill?
Not on behalf of the people.
Mr. Lee?
No, thank you, Your Honor.
All right, Mr. McGuire, good luck to you, sir.
If we could do Miller, please, Your Honor. That's Mr. Berman's case.
Daniel Miller, Mr. Silverthorne, and Mr. Berman. All right, so we're on the record in 25029. Let's make sure I have the right file, Miller. 2503041. That is people of the state of Michigan versus Daniel Sharice Miller. Appearances for the record, Mr. Berman.
Thank you, Your Honor. Randall Berman on behalf of the people.
Mr. Silverthorne.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Daniel Sharice Miller, who is not present.
This was scheduled for 9 o'clock. This is in front of myself. This is a Judge Flores case. It is now 9:55. It would appear that the defendant failed to appear for the probable cause conference. Mr. Silverthorne, have you had any contact with Mr. Miller?
I have, Your Honor, but let me make a record of the contact. I actually sent my first email about 9 days ago, and then another email and possibly a third one to his email that's listed on our file. I also made several calls and had to leave voicemails. Only last night at 6:44, I realized he must have gotten my email because he finally replied. He wanted to know which number he could leave at. What was 6:44? I just responded to him that I'll be in court at 8:15. I could meet him, or alternately, I could meet him in the breakout room on Zoom. And I also told him what my intentions were in terms of keeping on the prelim examination. And I left it at that.
All right.
I do not see him here today. He has been contacted. I don't know. I have no explanation to provide to the court today as to why he's not appearing.
All right, and I see the Zoom courtroom. Mr. Miller is not in the Zoom courtroom. Is there a representative or is for Daniel Miller in the Zoom courtroom? And I don't see anybody to that name in the physical courtroom. Based on representations of counsel who's reached out, it would appear, Mr. Berman, that Mr. Miller has failed to appear for the probable cause conference. How would you like to proceed?
Your Honor, I would ask for a bench warrant and bond forfeiture. I understand it's not a violent offense necessarily, so that if you wanted to do it with a 48-hour wait period, I have no objection.
All right. This is not an assaultive crime. There was a gun used or a gun found and a controlled substance. Defendant failed to appear for probable cause conference, and I'll issue a bench warrant with a 48-hour hold.
Thank you, Your Honor. I will.
If Mr. Silverthorne, if you're able to get a hold of him, you can contact Ms. Holden and we can just leave it on for prelim.
And I now know he received my email, so as soon as I go back to the office here very shortly, I will let him know what's occurred in court today and that he still has some time to repair it.
All right, thank you.
I just want to state for the record that I'd like to know ahead of time whether or not the officers, witnesses need to be here on it, because that would.
Yeah, contact Mr. If Mr. Silverthorne keeps it on, they may be, but if Mr. Silverthorne doesn't anticipate a preliminary examination, then you may not need to subpoena them.
And unfortunately, I really can't answer that question until I have contact with Mr. Miller because.
But yeah, and he's got 48 hours.
Right.
Yeah.
So I guess that's my point, is that if we don't hear from him within 48 hours,
he'll be on bench warrant status.
I'm going to call off the witnesses. Yes. If he does appear at the prelim, then we're going to treat that as a PCC with good cause for the fact he failed to appear today would be my request.
Absolutely. Let's see. There's bench warrant with a 48-hour hold. Let's see how that stands first.
Thank you, Your Honor.
Okay.
I agree, Your Honor.
All right. Anything else for the record? 2503041. Mr. Berman.
No, Your Honor. Thank
Mr.
you.
Silverthorne.
No, Your Honor.
All right. We're all set. Thank you for your appearance today.
Thank you, Your Honor.
Spearman, I will email you either way since it would be one of Megan or myself issuing.
Thank you.
That bench warrant will come through.
Thank you.
You're welcome.
Your Honor, if we could call Brandon Brown while we have Mr. Silverthorne.
Okay, that was Miller, and let's go on Brown.
Oh, okay, yeah.
He's already paid.
Oh, okay.
And is that an 8:30 on our docket?
Cool since January. So.
Okay, let me just pull up the exact chart.
All right, so that's Brandon Brown.
It's under the statute.
Yeah, you have it.
Yeah. The 90
Lovely.
days.
Yep.
Yeah, the 90 days, so that would be paid.
Yeah, I just need the number,
Yeah, oh,
the MCL.
okay. Yeah, section 9 of that MCL.
That's what we're calling as Brandon.
Yes, Your Honor. Yes, Your Honor.
All right, so we're on the record in 2502704. This is on Judge Flores' docket. People of the state of Michigan versus Brandon Brown. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Silverthorne.
Good morning, Your Honor. Dwayne Silverthorne from the Office of Public Defender on behalf of Brandon Richard Brown, who I see is appearing on screen via Zoom.
And sir, you are Brandon Brown, is that correct?
That's correct, Your Honor.
Right, and you can hear me all right, Mr. Brown?
Yes, I can, Your Honor.
All right, thank you. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, I do believe that the defense would like to plead to the offer that we had, which I believe we could do an amended count 1 of the 90-day misdemeanor sex offenders refusing or failing to pay registration fee. The MCL I have is 28.725A6. It should be a 90-day misdemeanor. It has come to the people's attention that the defendant has complied. So that is why we are extending misdemeanor.
All right, it's 90 days and or what's the financial amount on that? I would say,
It just says 90.
I think it's 500.
I think it's 500.
Yeah, sorry, my warrant
That-
manual. Excuse me, my
And
warrant
this would
manual
be this would be the misdemeanor sex offender for, is it failed to pay?
Yes, it's the failing to pay registration fee.
All right, so, and is that a fair and accurate offer that was made? It would be to amend count 1 to the sex offender misdemeanor failed to pay. That's under MCL 28.725A6. I think that's an MSA. Is it an MCL or an MSA?
It's an MCL is what I'm showing.
28.725A6. It's a 90-day misdemeanor and or I'm pretty sure it's $500. Is that a fair statement, Mr. Silverthorne?
Yes, Your Honor.
All right. May I inquire of Mr. Brown of his misdemeanor advice of rights?
Please, Your Honor. Do.
All right, Mr. Brown, you understand you have the following jury trial rights. I'm going to walk you through them, okay?
Yes, Your Honor.
All right, you have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by attorney Dwayne Silverthorne. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You have the right to have the court order any witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial. Since you'll be pleading guilty to the misdemeanor instead, you won't be having a trial today. Is it still your wish today to waive your jury trial rights and plead guilty to the misdemeanor, Mr. Brown?
Yes, Your Honor.
All right. I'm going to have you raise your right hand as best you can. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
I do.
All right. You can put your hand down, sir. I'm going to bring your attention back to July 1st, 2024 in the city of Lansing. Were you present on July 1st, 2024 in the city of Lansing at 1616 Coleman Avenue in the city of Lansing?
Yes, Your Honor.
All right. And then do you want to
listen because it's a little more sophisticated?
Okay. You can ask your client some
Yes.
questions.
On July 1st, 2024, is it true that you were registered with SORA if they were to look at 1616 Coleman Avenue, Lansing, Michigan?
Yeah.
Okay, but in fact, you had left the household at that time, is that correct? You had left that residence at that time, okay?
Yeah.
And you did not report that to SORA, correct?
Yes.
And then you re-registered at a new address in January of 2025, correct?
Yes.
And what address is that? Well, actually, because this is a record, you've registered a correct address, is that correct?
Yes.
Okay, and that's on record with the state of Michigan?
Yes.
And that's it's current, right?
Yes.
But there was a period of time you didn't pay the registration fee, and that since has been brought current too.
Yes.
Is that correct? Thank you.
Yes.
All right. Anything towards a factual basis, Ms. Fortuna Gill?
The people are satisfied.
Mr. Silverthorne?
We are satisfied, Your Honor.
All right. I find that the factual basis to the misdemeanor failed to pay registration to be knowing, voluntarily, and accurately made. Ms. Fortuna Gill, did you want this referred to probation, or can we go to immediate sentencing?
The people have no objection to immediate sentencing.
All right. Mr. Silverthorne, I'm assuming you have no objection to immediate sentencing.
No, I prepared the defendant for that. I indicated that sometimes there might be probation, but he's sort of on a form of probation because he registers.
Right.
And he's paid the fine, so I'm just gonna leave it to the court's discretion at the sentencing.
All right. All right. I think we can go to a immediate sentencing on the matter. And you've kind of made an allocution statement, Mr. Silverthorne. Anything else you want to say in regards to allocution on Mr. Brown's behalf?
Not really, Your Honor.
All right. Mr. Brown, do you have anything to say to the court before the court passes sentence on immediate sentencing today?
No, Your Honor.
All right. Thank you. With the understanding that the defendant is currently on registration, I'm going to set fines and costs at $100 fine, $100 cost, crime victims' rights fee of $75, state fee of $50. No upfront, there's going to be no jail and no probation. And we'll set it at so it's $325 to the city of Lansing. And Mr. Silverthorne, does your client need some time to make that payment?
I would have to inquire, but would it go to the city of Lansing or it is the city of Lansing?
Yeah, it's the city of Lansing.
Okay. Sir, when could you pay that? It's a total of $325.
Am I able to go to any pay? It doesn't need to be made in full all at once.
Well, generally there can be some
I can set it out and then you can make a payment as you go. As long as it's all paid out by that date, I can give you 90 days.
Absolutely, I can make that happen, Your Honor.
All right. So let's get a date set. 90 days out.
January 15th,
Okay.
2026.
Yeah. So it's all to be paid to the city of Lansing by January 15th, 2026. And you can kind of make your own payment plan as long as it's all paid by that date. All right, sir?
Yes, Your Honor.
All right. If you fail to make a payment and don't explain why, they'll show cause you. That's generally what happens. So you want to stay out of that show cause cycle. All right, sir?
Yes, Your Honor.
All right. Anything else for the record in 25-02704, Mr. Silverthorne?
Oh, Your Honor.
Ms. Fortuna Gill.
Not for the people.
All right, Mr. Brown, by January 15th, it'll be $325 to the city of Lansing. Thank you you can pay online, in person, or by phone. Thank you for your appearance today, sir.
Thank you, Your Honor. Thank you, Mr. Silverthorne.
You're welcome, sir.
Background from the jail. So I almost don't want to mute it because you may never get them back. All right. Mrs. Kachukas, do you have anything?
Yes, I believe Mr. Goodrich and I are ready on Miss Calvert. Calvert, yes.
Or Miss Calvert. That's Mr. Goodrich.
Yes. I believe we'll also be ready on Mr. Black.
I'm not schizophrenic. I'm cool.
This is Mr. Goodrich's plan. All right, so we're on the record in docket 25-03006. That is People of the State of Michigan versus Marquita Calvert. Appearances for the record. Why is that? Why am I hearing myself? Jail.
That's a tablet.
Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office here to represent Ms. Calvert, who's appearing over Polycon from the Ingham County Jail today.
All right, ma'am, you are Marquita Calvert, is that correct?
Yes.
All right, and And you can hear me all right, Ms. Calvert?
Yes, I can hear you.
Thank you. This is the time set for a probable cause conference. Mr. Goodrich, how are we proceeding? Or Ms. Kachukas, how are we proceeding? Would you like to defer to Mr. Goodrich?
Your Honor, the people have extended an offer that Ms. Calvert may plead to an added count 3 of use and an amended count 2 of attempt resisting and obstructing in exchange for dismissal of count 1 and dismissal of the habitual offender notice. It's my understanding that Ms. Calvert intends to plead to that today.
Is that a fair statement, Mr. Goodrich?
Yes, it is, Your Honor.
All right. So let me look at the. And I might need for you to reiterate. So it's a two felony count. And what's the offer?
The offer, it would be dismissal of count 1, plead to an amended count 2, where it becomes an attempt.
Okay, so attempt to count 2.
And then plead to an added count 3 of use. And I have the PAT code in the courts right.
Okay. The attempt R&O is punishable by 1 year and $1,000. Is that a fair statement?
That is my understanding, yes. Your
And the PAT code would be 750.81D1A. Is that? I think it's just.
It should be the same plus
yeah,
A, yes.
Plus an A. All right, and then count 3, an added count 3. This would be an amended count 2. Would be a use of cocaine or use of a controlled substance.
Yes. And the PAT code for that is 333.7404.
And that's punishable by 1 year. And what's the financials on that?
$1,000.
$1,000. All right. So my understanding, Mr. Goodrich, is the defendant's going to plead to a misdemeanor count 1 of amended count 2 of an attempt R&O, punishable by 1 year and or $1,000, and an added count 3 of use of a controlled substance.
Yes,
Under 333.74042B, that's punishable by 1 year and or $1,000. Is that your understanding of the plea agreement, sir?
Yes, it is, Your Honor.
All right. All right. May I inquire of Ms. Calvert of her advice of rights?
Yes, Your Honor.
All right. Ms. Calvert, I'm going to have you raise your hand. All right, thank you. All right. You understand you have the following jury trial rights, and I'm gonna walk you through those. You can put your hand down, ma'am. You have the right to be tried by a jury, to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses that are brought against you. You are represented today by Attorney Luke Goodrich. He would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, ma'am?
Yes.
All right. You have the right to have the court order any witnesses appearing in your defense to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what's been stated on the record or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal any issues from trial. Since you won't be having a trial, you'll be pleading guilty to the amended count 2, a misdemeanor attempt R&O, and the added count 3 of a misdemeanor use of a controlled substance. Is it still your wish today to plead guilty to the 2 misdemeanor counts?
Yes, sir.
All right, thank you. I'm going to have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
All right. I'm going to bring your attention, ma'am, back to October 2nd, 2025 at the location of 400 South Capitol in the city of Lansing. Were you at the 400 South Capitol address in the city of Lansing on October 2nd, 2025?
Yes, sir.
And were you approached were you approached by a Lansing police officer in full uniform, Officer Ella Brown?
Yes.
And what did you do concerning Ella Brown's that confrontation that makes you guilty of resisting and attempted resisting and obstructing Miss Calvert?
When the police pulled up onto the park address, I ran.
Okay, you ran when. Did you wait for an instruction, or did you hear an instruction indicating that you were not supposed to run at that time?
After I began, yes.
Okay. Anything towards and that instruction came from Officer Ella Brown of the Lansing Police Department. Is that correct, ma'am?
Yes.
Anything else towards the factual basis, Ms. Fortuna Gill?
No, Your Honor.
Mr. Goodrich, anything towards, Mr. Kachukas?
No, Your Honor, I didn't have anything either.
All right. Anything towards the factual basis on count 2, Mr. Goodrich?
No, Your Honor. Thank you.
All right. In count, the amended count, the added count 3, were you at the same location, 400 South Capitol on October 2nd in the city of Lansing? Ms. Calvert?
Yes, sir.
And did you use a controlled substance at that time, specifically cocaine?
Yes, sir.
And you knew it was cocaine when you were using it, is that correct?
Yes, sir.
And you didn't have a prescription to use cocaine at that time, is that correct?
Correct.
All right, anything towards a factual basis on the added count 3, Ms. Kachukas?
Not from the people, Your Honor.
Mr. Goodrich?
No, Your Honor. Thank you.
I find the factual basis for the amended count 2 and the added count 3 to be knowing, voluntarily, and accurately made. We will refer to probation. This is Calvert's is Judge Ward's document. I don't plan on taking the sentencing. Okay. I'm just referring to probation until we get a report for sentencing. So I think Judge Ward would probably get the sentencing. That's I think, but I can. Mr. Goodrich if Judge Ward is doing the sentencing, you don't have anything to do. We're just going to refer to probation. If I'm doing the sentencing, I think we'd have to have a waiver whether I can do the sentencing or not.
Your Honor, Ms. Calvert would waive the right to be sentenced by the same judge as taking the plea. It's perfectly fine to just be sentenced by Judge Ward in this matter.
All right. So Judge Ward will do the sentencing. Do we have a sentencing date for?
I do.
Okay.
December 12th at 8:30.
December 12th at 8:30. And then probation, ma'am, will come down to see you. They'll do a report for Judge Ward, and the sentencing will be held on December 12th at 8:30. All right, ma'am?
Do I have to stay here until December 12th?
Well, Your Honor, we would like to address bond before we finish the hearing.
All right. So you may address bond before we finish the hearing, and then I'll get a response from the prosecutor on the case. Mr. Goodrich, you may address bond. Obviously, there's no more felonies. We pled to 2 misdemeanors. So, Mr. Goodrich, you may proceed.
Thank you, Your Honor. Your Honor, her bond was set at 10% in this matter. As the court is probably gleaned from the factual basis, is a situation where the police showed up at the park just to check on people who were there after dark, and she took off running because she'd been, using cocaine. There was no violence. She ran about half a block and fell down. There was no fighting with the officers or anything along those lines. She has a place that she can stay with a friend in Capitol Commons while this is ongoing. She has been working with CMH both prior to being in jail and since she's been at the jail. I've spoken with her case manager, Dennis Cochran. He's been aware of the situation. So I would ask the court to consider changing this into a PR bond at this time now that the felony charges are gone. Thank you.
Thank you. Ms. Kachukas on bond.
Your Honor, as long as the defense has a good way to get in touch with their client and she has somewhere to go, I have no objection at all.
All right. This has been reduced to 2 1 years for misdemeanor. Mr. Goodrich, you can get in touch with Miss Calvert.
Yes, we do have a phone number for Ms. Calvert, yes.
All right, I'm going to modify bond, but I'm not gonna PR bond her. This is a 4th offense notice. So she's had R&O on 1, 2, 3 prior R&Os, but I will reduce the bond because we're dealing with misdemeanors now. I'm gonna set bond at $500, 10%. So she'll be a 10% bond at $500. Anything else for the record in docket 25-03006, Ms. Kachukas?
Not for the people, Your Honor.
Mr. Goodrich.
And Your Honor, I would just like my client to be aware that that would be a bond requiring $50 to be paid, and that I will contact her aunt after today's hearing.
Okay,
All right,
thank
so
you.
that's an accurate statement. It's a $50, set at 510%, which is $50. Thank you for your appearance today. You're all set, ma'am.
Thank you.
So that is
Ready on, yeah, ready.
Calvert.
And we're ready on flag as well, Your Honor.
On the flag. Richard?
Yes.
All right. Okay.
I put it in one of the files. He's got 2. I'm not sure which one I put.
All right.
I forgot to ask for stuff. I'm assuming it's for both files.
That's on 2735. And then
You have another file somewhere up there.
oh, I only have one. One is up for contempt and one is,
My
so they're all, so the same file.
Correct, Your Honor. Yeah, the contempt is not a PA 53 no contact. It's because they picked up those trespassing charges, which are also pending before Judge Warrior's court date on that, though.
All right. All right, so we're on the record in 25-02735. That is People of the State of Michigan versus Richard Flagg. Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas with People.
Mr. Sartz.
Good morning, Your Honor. Jacob Sartz, the 4th Assistant Public Defender here on behalf of Richard Flagg. I'm appearing in person this morning, and Mr. Flagg is appearing by Polycom from the Union County Jail.
And sir, you are Richard Flagg, is that correct?
Yes, sir. Yes, Your Honor.
All right, thank you. And you can hear me all right, Mr. Flagg?
Yes, Your Honor.
All right, thank you. This is the time set for a preliminary examination, probable cause conference. Ms. Kachukas, how are we proceeding, or would you like to defer to Mr. Sartz?
Your Honor, it's my understanding that there may be a competency concern at this time. And based on the history that I was able to look through in Mr. Flagg's old files with our office, that is consistent. So I will defer to Mr. Sartz as to how to proceed with that.
Mr. Sartz.
Thank you, Your Honor. Yes, respectfully, I request that Mr. Flagg be ordered for competency evaluation on this file. For the reasons I stated in my petition, I understand this petition may upset Mr. Flagg, but professionally, I need to do this based on the circumstances, based on his past history. Respectfully, Your Honor, as it relates to the PA 53, those allegations are not due to any allegations of no contact violations or anything along those lines. The bond violation stems from new trespass charges, which have been issued, which have been pending. Respectfully, Your Honor, I would just request that the bond allegations be dismissed at this time. Mr. Flagg's bond was adjusted to $10,000 cash surety. That's a pretty serious message to Mr. Flagg. He understands the importance of complying with the court's orders in the future. And plus, he's presumed innocent on the trespass charges. And obviously, based on this request this morning, I anticipate there could be some substantial delays. I did reach out to his caseworker about his bond, Mr. Cochran. They are aware that he's in custody, Your Honor. I'm not sure if they're going to have the means to be able to post that bond, but in the meantime, respectfully, because he has those new pending charges, I would request that the bond allegations be dismissed at this time.
All right, Ms. Kachukas.
Your Honor, I would just ask that the bond allegations be kind of indefinitely deferred because it is connected to a another criminal offense, obviously he wouldn't be able to plead on the bond allegation since it's connected to a trespass.
And bond was set on the violation, on the contempt for 10,000 cash surety for the PA 53. I don't know who set that.
Judge Paul, I believe, Your Honor, when he got rained on. I could be mistaken, but it was the reigning judge at the time.
All right, so, and I do have a fail to appear on the actual file. That was September 19, 2025. The defendant failed to appear. I'll modify the bond. I think it's pretty high. So we'll set bond, I'll make a bond modification on the PA 53. I'm gonna grant the prosecutor that we'll place this in abeyance and address this with the underlying file, which is what is the petition requested. And I'll modify the bond at 5,000, 10%. I'm gonna set bond on the PCC. I'm gonna set bond on this file to 3,000, 10%. And then I'm gonna sign the evaluation based on the contents and the history. Now, the further request is this, because you know Judge Ward better than I do. Is the petition should take it off the prelim docket?
Yes, Your
Yeah,
Honor.
I would assume, okay.
Yeah, we'll have review hearings scheduled in the meantime, but yes, it should be
Perfect,
removed.
perfect. All right, and there's a copy. Do you want me to sign both? Because I've got two. I got a copy and I can sign them both.
That would be fine.
All right, just to save time so we don't have to make a copy. All right, I'm gonna sign on today's date, 10/17. So I'll sign the petition.
I try to impress me. That's why I get glad to death. From you all that bullshit, yo. Downtown, sorry.
All right. And then this will be placed on Judge Ward's docket. I'm going to indicate that I signed the petition. Yeah, and if Judge Ward has a review date, we'll, okay, but sign petition for forensic, and we'll set it for review date.
January 29th, 2026 at 8:30.
And this has been set on for review of the petition and the interview to be on January 29th at 8:30. This will be reviewed on Judge Ward's docket. Anything else for the record in docket 25-02735?
Not for the people, Your Honor. Not for the people, Your Honor.
And I'm going to put it on both dates. Anything else for the record on 20? Mr. Sarks.
Nothing further, Your Honor. Thank you.
You should be all set. Thank you for your appearance today. And Mr. Flagg, you'll be in Judge Ward after the interview. Okay, sir?
Say that again, Your Honor.
So you'll be in front of the different judge, Judge Ward, and any questions can be directed to Mr. Sarks.
Yes, Your Honor.
All right. Thank you, sir.
Yes, Your
You're all
Honor.
set.
You're all set.
All right. So I'm gonna take like 10 minutes.
Okay.
And then we'll do the rest of, I think we've got 3 left on Judge Ward's, and then we've got the rest on our docket. Let's take 10 and then we'll come back and just let us know you're ready. We'll come back in 10 minutes.
I'm so sorry.
Can I get this other one, please? Gotta get both. Yeah, this. Doesn't go the other side. Thank you. Yeah.
Anybody I've talked to, they said, boy, what'd you do with them?
Brand new?
I wish you would have done 6 months ago.
Mhm.
Here and ready. All right, thank you.
Yep, you're Miss Earl, right? You can have a seat. I don't know where you're, I don't know where. Do you know who's covering for Donnelly? I would-
Mr. Frim, for Dolly?
Yeah,
Yeah, that's me.
okay, that's Miss Earl right there.
They like to say a lot.
Oh, yeah. Yes, I am. Yes, I am. Is it? Yeah.
Yes, I know you're here.
No,
We got, we're
no,
running two dockets.
No, I completely understand. My only thing is supposed to be in Eaton County in 28 minutes.
That's not anything that I can do. You're gonna have to talk to the prosecutor.
All right, thanks.
Yeah.
Sorry.
So, you want it? I got it right there. Did you fall under? Contributor like the Psalms 37 campaign. A lot contributed to Psalm 37. I'm going to go to some God concert. And it's just like. I'm sorry, Mr. Black. Leave me alone. Choose to Psalm 37. That's all. Such my weird. I'm really sorry for that man. For that boy. Leave him alone. But he knew he was possessed. Let me tell you what the Harvard shit is about. I swear on his head again. She was about to Psalm 77 county. It started this game, didn't he? And I swear on his head again. She did my whole life. Mama, they saw her son, she said he was 9 years old. By someone else possessed. I got the nervous sitting on the I dropped something in your buttons. And all I was trying to do was make it just like Johnson too. Enjoy. Trying to feel sorry. Be that man alone, yo. Be that man alone. There ain't nothing to do. Be that man alone. I ain't never had a store bag in 20 years. I was 20 years, I've never been committed yet. I never had a store bag. Always. Give me. Yeah, man, I'm walking. You all right? Yeah. Bro, come fuck on. And they can teachers like. Well, I was gonna take breaks. It was hard to shit. So weird ass. Focus. They broke that man's spirit. And I swear on his head. I swear on his head.
All right, so what are we calling next, Miss Fortuna Gill?
If we could do Waters, Your Honor.
Waters.
Associate that with racism, with murder, all types of shit. They did him like a white boy for real.
In Ingham Jail Post 2, you should stop talking, sir, so we can hear everything you're saying. All right. All right, so we're on the record in docket 25-01457. That's people of the state of Michigan versus Brian Waters. Appearances for the record. Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Coons.
And good morning, Your Honor. Dustin Coons for Brian Waters, who's here to my right.
And sir, you are Brian Waters, is that correct?
Yes, Your Honor.
Thank you. This is the time set for a sentencing in the matter. And I don't have any other restitution than there's a blank on restitution, Ms. Fortuna Gill. Are you aware of any other restitution in the matter?
There is no restitution on the matter, Your Honor.
All right. Mr. Kuntz, have you had the opportunity to go through the pre-sentence report with your client?
Yes, Your Honor.
Any additions, deletions, or corrections?
Just one update to the body of the report. At the time my client did his interview, he was unemployed. He's since gotten a job, so that should be updated. And then one other thing that isn't really a factual dispute, but something I'd like to address in allocution.
All right. And where's the employed at?
Williams Distribution.
And is that full or part-time?
Full-time, Your Honor.
Allocution, Mr. Kuntz.
Your Honor. So I guess I'll start with the part of the pre-sentence report that I'd like to address. So it recommends that my client take some classes because he did not accept responsibility for his acts here. And I guess my dispute there is he did accept responsibility. He accepted a plea offer extended by the people, and he pled no contest, and there are reasons for that, namely civil liability. He's already, as a result of the same conduct that made up the allegations in this case, that led to his conviction in this case, he faced a Title IX investigation at Lansing Community College. He lost his job as a result. There's certainly a possibility of further civil litigation due to this. So him not giving a statement, I guess I'd ask the court to blame me. Remember early on in my practice, I had a no contest plea in Clinton County from Judge Tavonen, and then my client gave a statement in the pre-sentence report, and then Judge Tavonen made it clear to me that part of why you take a no contest plea is so you don't have to say anything on the matter. So ever since then, I've always told my clients to take no contest pleas, don't say anything.
Right.
So again, blame me, not my client. He has accepted responsibility. Of course, he made some poor choices that led to this conviction. But standing next to me is also a man who just turned 55 last week and has absolutely no criminal history other than this. He's a man who's been married to his wife, Nicole, for, I'm not even sure how many, 25 years. They've raised two amazing boys who put them through college. And obviously, the conduct that led to all of this has been, it's been a rough stretch for their family and the victim, and I recognize that, but they're putting back together the pieces. I think ultimately the recommendations made by probation are appropriate. I'd ask the court to, I don't know that cognitive behavioral therapy is necessary. Again, looking at the whole of my client's 55 years on earth, not just this one instance. But I think 12 months probation is appropriate. I ask the court to hold all possible jail time in abeyance and let my client prove himself to the court.
Thank you.
And I should say, and the court can blame me on this too. I've instructed my client not to say anything today.
All right. Anything from the people before I address Mr. Waters with the understanding that Mr. Waters has been instructed not to indicate anything to the court? Anything you'd like to say, Ms. Fortuna Gill?
The people leave it to the court's discretion, Your Honor.
All right. And then Mr. Waters, based on the recommendation of counsel, you have nothing to say to the court. You're speaking through your lawyer. Is that correct?
That's correct, Your Honor.
All right. Thank you. All right. So this is for a no contest plea to aggravated assault on August 8th, 2025. It is ordered the court that the defendant spend 180 days in jail. Credits given for 1 day previously served. I'll suspend the 180 days upon successful completion of probation. We'll set fines at 300, costs at 300, crime victims' right fee of 75, state minimum cost fee of 50, probation, placing you on a month, 12 months probation. Your probation agent would be Brendan Hanna, who's pretty flexible. He's a pretty easy guy to work with. And I'll give you a round number on that. 50 plus 360. So it'll be 1,085. So probation is sent via Zoom. You might want to get with the probation department just to know how that entails, the ID number, what how that entails. There's to be no contact with the victim in this case, Yuritsi Hernandez Resendez, and that's 2,000 feet of where the victim lives, works, or goes to school without the consent of this court. No assaultive or threatening behavior. No use of possession of alcohol, marijuana, or controlled substance. Submit to random PBTs and urinalysis as directed. No bars or nightclubs. I am ordering the cognitive behavioral therapy. That can be discussed with Mr. Hanna. So whatever he comes up with that would suffice for his, it could be a day class. It could be something online. Okay, we'll see what he says on that. But I am ordering that complete following rehabilitative services, pay fees, and provide proof of completion to the court. Obtain and maintain employment, which you, the update is you have availed yourself to, and not purchase or possess firearms, ammunitions, or weapons of any kind. Mr. Kuntz, do you have any questions concerning the judgment of sentence?
I may, Your Honor, can I have just a moment?
Sure.
Your Honor, would it be possible to, of course, the no contact order stays in place, but to narrow the distance, 2,000 feet? I'd suggest maybe 500 to 1,000. The workplace, and my client is a former colleague of the victim in this case. Workplace is Lansing Community College. My client's wife still works at Lansing Community College. And it's just kind of in the heart of downtown. So it's hard to live in or around Lansing and not go within 2,000 feet at some point.
Yeah, I'm good with 1,000 feet. So I can reduce it to 1,000 feet of where the victim lives, works, schools, or goes to school, which would be LCC, and that might take care of some of the zone. What I would recommend is we get a copy of the judgment of sentence, and so you carry it with you if there's a problem there. All right. But I will address $1,000 foot. So stay within 1,000 feet of Miss Resendez, and that would be Lansing Community College where she works. Anything else concerning the judgment of sentence, Mr. Coons?
No, thank you, Your Honor.
Ms. Fortuny, go.
No, Your Honor.
All right, we'll make that one look pretty. I got my writing all over that. All right, Mr. Waters, make sure you know how to contact your probation agent. He would be the one who's violating you. You should be all set, sir. Thank you for your appearance today.
Thank you, Your Honor.
Mr. Freeman, you ready? Do you want to do your cases?
Sure.
We're ready on Sawicki. Excuse me.
No, I don't think so.
Oh.
All four are.
Okay. Okay. Yeah. Got it.
Thank you.
Oh, yeah. Did I put $300 for costs?
That's what you said.
Yeah.
Yeah.
It's not on here.
Oh, I'll fix it.
That's all right. I'll just write it in. So $300 fines and $300 costs, correct?
Yes.
For 600, okay.
Which
Because
one?
the total's right, it's just,
Oh, I can
Right.
put.
no,
Yeah, look for a second.
it's not worth it.
I must have
Not worth the hassle.
been typing in notes instead of on the JR. Sorry.
All right,
Okay.
Mr. Waters.
Here's the yeah, big stuff.
right, what did you want to call next, Miss Fortuna Gill?
We're ready on Sawicki,
Sawicki.
and I believe Mr. Freeman's covering for Miss Donnelly on her case,
All right.
to him as well.
All right, so that'd be both files. And did you want to call both those files together?
That's fine with the people.
All right. All right, so we're on the record in docket 25-02402 and 25-02452. That is people of the state of Michigan versus Savion Sawicki. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Freeman.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, on behalf of Mr. Sawicki and file 2402 in the place instead of Attorney Sarah Donnelly for purposes of PCC today. And I am appearing also in the companion file 2452 as attorney of record in that file, if that would please the court.
All right, and then Mr. Sawicki's joining us from the jail.
Yes, Judge.
And sir, you are Savion Sawicki. Okay. So, sir, and you can hear me all right, Mr. Sawicki?
Yes, I can hear you.
All right, thank you. This is the time set for a probable cause conference on two files, 25-02402 and 25-02452. Ms. Fortuna Gill, how are we proceeding?
Your Honor, I'll defer to Mr. Freeman.
Mr. Freeman.
Thank you very much, Your Honor. With respect to file 02402, on behalf of the defendant as well as Ms. Donnelly, my understanding is that there are negotiations continuing but not completed. And so we'd like to leave that on for preliminary exam with the understanding that more likely than not, it will be a waiver or a plea. Thank you.
All right. All right. So on file 25-02402, we're going to leave on for preliminary examination. That'll be live on the 6th floor City Hall of Lansing for it's October 29th at 8:30. October 24th.
24th.
I was looking at the wrong one. That's the original. October 24th at 8:30. So we've left on for prelim on October 24th at 8:30. Anything else for 25-02402, Ms. Fortuna Gill?
Not for the people.
Mr. Freeman.
No, Your Honor.
And then we'll call 25-02452 as previously indicated. And Ms. Fortuna Gill, would you like to defer to Mr. Freeman on that?
Yes, Your Honor.
All right, Mr. Freeman.
Thank you very much, Your Honor. I've had an opportunity to speak to my client on this case. And the long story short is there are some issues that we'd like to address at a preliminary examination. If we could continue as currently scheduled, please.
All right. So leave on for the previously scheduled preliminary examination for October 24th at 8:30. And then, Mr. Freeman, if there's any discovery of issues, you'll let Ms. Fortuna Gill know before the hearing.
Yes, Your Honor, I will. Thank you.
All right. Anything else for the record? In 25-02452, we've left that 25-02452 left on for preliminary examination for October 24th at 8:30. Anything else, Ms. Fortuna Gill?
Not for the people.
Mr. Freeman.
No, Your Honor. Thank you.
All right, Mr. Sawicki, you should be all set. We'll see you next week. Thank you for your appearance today.
We are ready on Kane while we have Mr. Freeman up here.
Kane. Right, so we're on the record in docket 25-02915. That is people of the state of Michigan versus Josiah Kane. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Freeman.
Good morning, Your Honor. Stephen A. Freeman, Public Defender, on behalf of Mr. Kane, also incarcerated.
And sir, you are Josiah Kane, is that correct?
It was on that turn shit.
Sir, are you on Josiah Kane? You can raise your hand. Josiah Kane. Who's here? In post 1, please identify yourself. Sir, you're in visit 6, post 1. I don't know if they know who I'm talking about. All right, let's do this. Is there a Kishan Foreman? Kishan Foreman, all right. We've identified yourself, Zachary Kelly. Is there a Zachary Kelly? All right, thank you, sir. A Lauren Morris. Is there a Lauren Morris?
What about you? What you know about that? They don't exist. All that magic Johnson neither. No, that don't matter now. Watch.
Your Honor. Your Honor, this is Richard Flagg. I'm still in the waiting room waiting for Mr. Starks. Is he coming?
Just like that's just how it's bad. You know that. I don't believe me. It can either take just like Magic Johnson to, you know, all that. Not much musty stuff. Yeah. You know why? How we burst. Musties. It's just like having us small to just like yeah. Tired of shit. Stay with the whole world.
All right, Keyshawn Foreman, I'm going to call your case. Keyshawn Foreman. All right. So we're on the record in docket 25-02321. That is People of the State of Michigan versus Keyshawn Foreman. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Freeman.
Good morning, Your Honor. Stephen A. Freeman, Public Defender on behalf of Mr. Foreman, who joins us via Zoom.
All right. And sir, you are Keyshawn Foreman, is that correct?
You have to say yes or no.
Sir, you are Keyshawn Foreman, is that correct? Let's move you close. Move you closer to the mic. I can't hear you.
Okay,
sir. Okay, sir, are you Keyshawn Foreman? You can raise your right hand. All right. For some reason, we can't hear out of that, but I see Mr. Foreman. He raised his right hand. Ms. Fortuna Gill, how are we proceeding today on the probable cause conference?
I will defer to Mr. Freeman.
Mr. Freeman.
Yes, Your Honor. Thank you very much. I've had an opportunity to speak to Mr. Foreman, and he indicated to me that I guess members of his family had contacted Attorney Toby White, and I contacted White. And my understanding is that one of the associates there, a female attorney, has twice visited Mr. Foreman at the jail, but I have not seen a substitution. So I think I'm committed to leave it on for the exam and just we'll see if he submits a substitution.
All right. So
They are supposed to be on Zoom. I got a message from them. About 9:31, it says, oh, I'm sorry, wrong one. Apparently they're representing a different.
all right. We will await an appearance from the Toby White Law Firm concerning Mr. Foreman, but we'll leave on for preliminary examination until then because we're not sure. So we'll leave on for October 24th at 9:30.
Ready, yes, yeah.
All right, so I'm leaving file 23-02-321 on for preliminary examination on October 24th at 9:30. Anything else for the record for that file, Ms. Fortuna Gill?
No, Your Honor.
Mr. Freeman?
No, Your Honor. Thank
All
you.
right. All right, Mr. Foreman, you're all set. Thank you for your appearance today.
And then we have Dyron Jackson, who is present, and that's also Mr. Freeman's case.
All right.
That'll be for a plea regarding a resolution of the case, Judge.
Let's Dyron. Here we go. I don't know. We did. We have two Jacksons. They're right next to one. All right.
That's what they told me to do. That's what I did.
All right. So we're on the record in docket 25-03045. That is People of the State of Michigan versus Dyron Jackson. Appearances for the record, Ms. Fortuna Gill.
Good morning, Your Honor. Haley Fortuna Gill on behalf of the people.
Mr. Freeman.
Yes, Your Honor. Good morning. Stephen A. Freeman, public defender. On behalf of Mr. Jackson, who was also present in the courtroom.
And sir, you are Dyron Jackson, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for a probable cause hearing. Ms. Fortuna Gill, how are we proceeding?
Your Honor, at this time, I believe the defendant will be availing himself of a plea offer that we extended to plea to count 4 and to dismiss the remainder. So counts 1, 2, and 3 would be dismissed with a successful plea and sentence to count 4.
And so does the plea to count 4, which is the aggravated domestic violence, and then counts 1 through 3 are to be dismissed upon successful plea and sentence.
That is correct, Your Honor.
Is that your understanding, Mr. Freeman?
It is, Your Honor. Thank you.
All right. And may I inquire of your client of his advice of rights?
Yes, Your Honor. Please do.
All right. Thank you. Mr. Jackson, do you understand you'll be pleading to the count 4 aggravated assault, aggravated domestic, comes with a penalty of 1 year and or $1,000. Do you understand that, sir?
Yes, Your Honor.
Okay, I'm going to read to you some jury trial rights you have in this matter, and then you can indicate whether you're going to waive those or not. Okay, sir?
Yes, Your Honor.
You have the right to You have the right to be tried by a jury, the right to be presumed innocent until proven guilty, to have the prosecutor prove beyond reasonable doubt that you are guilty, to have witnesses against you appear at trial, to question any witnesses are brought against you. You are represented today by Attorney Stephen Freeman, who would be present to cross-examine any witnesses or contest any charges brought against you by the people of the state of Michigan. Do you understand that, sir?
Yes, Your Honor.
You have the right to have the court order any witnesses appear in your defense, to remain silent during the trial, not to have that silence used against you, and to testify at trial if you choose to testify. If your plea is accepted, you'll give up the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. You'd also be giving up the right to appeal anything from trial, since you won't be having a trial. You'll be pleading guilty to the misdemeanor count instead. Is it still your wish to waive your jury trial rights and plead guilty to the misdemeanor count 4 misdemeanor count?
Yes, Your Honor.
All right. I'm going to have you raise your right hand, sir. Do you promise or swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, Your Honor.
All right. I'm going to bring your attention back to October 6, 2025 at 929 West Kavanaugh Road in the city of Lansing, Ingham County, state of Michigan. Were you at the West Kavanaugh address in the city of Lansing, state of Michigan, Ingham County on October 6, 2025? 2025. And at that time, who is Jessica Marie Jackson to you?
That was my girlfriend at the time.
Okay. And so you were involved in a dating relationship with her?
Yes, sir.
All right. You are pleading guilty to offensively touching and causing an aggravated injury to Miss Jackson on that date and time. So explain to me what you did not in self-defense. It can't be in self-defense. What you did with Miss Jackson that makes you guilty of the domestic violence aggravated.
I had my bag and she wanted to pull me back, so I pushed her out the way. She fell on the floor. I don't know if she hit herself or hurt herself when she fell, but I left after that. So I pushed her kind of hard to get out of the way.
All right, so that's the offensive contact with another. That was not done in self-defense, is that correct?
No.
And then the injury, there's no dispute. You're not disputing the fact that
The person was so thinking that I jumped the fence. Even if I could hear him jump the fence, he doesn't shoot me in my back. And so, you know, just like giving a baby poison or giving a white boy fentanyl, that's what they did. Some fucked up shit like that.
what is the is it the amount of injury that raises it to aggravated assault, or is it there's no prior?
Yes, Your Honor, the indication from the law enforcement was that LFD was called and she was taken to Sparrow.
Okay.
And treated, I think released, but sufficiently that it would constitute aggravated.
All right, there was a need for immediate medical treatment and you did not dispute that, is that correct?
That is correct, Your Honor.
All right, anything towards the factual basis for count 4, Ms. Fortuna Gill?
No, Your Honor.
Mr. Freeman?
Nothing further.
I find the admission to count 4 to be knowing, voluntarily, and accurately made. We will refer to probation. All right, so probation is 1 floor down all the way to your right. And they'll either set up a meeting to talk to you now, or they'll give you they'll get a date. They'll give you a date to talk to them. And we'll set a sentencing for
December 12th at 9:30.
December 12th at 9:30. So we'll set sentencing for December 12th at 9:30. We'll see what options are available to us on that date. All right, sir?
One question. I got a tether exclusion to go to work.
Yeah.
I'm wondering.
So I've gotten that there's a zone restriction concerning, so I'm gonna modify any zone restriction, but you should carry something that you're doing, because they're gonna request it, okay? They're gonna say, is it work related? So I'll modify the zone restriction with proof that you're at work or it's work related. But if you get stopped, so you won't be violated on that, but you should carry something that these are your work hours, or that some type of notice to go to work. So you have to show them that if you get stopped for anything. All right. All right.
So I still have to come to court on the 24th?
Yeah, so that's your sentencing. No, you don't have to come on the 24th.
Okay.
Your sentencing is on December 12th, and you should go to probation to set up a meeting so they can do a report for me. All right, sir?
Thanks.
So, all right, so Mr. Jackson, another way to do that is go ahead and tell JSG your work hours.
Okay.
And then that'll keep the monitor from going off.
Okay.
So if you tell them, like, I'm working these work hours this week, that'll keep the monitor, because I'm modifying the bond that you're good with work hours. So if you let them know, it'll keep it from going off. All right. All right. Anything else for the record? 2503045. Ms. Fortuna Gill.
Not for the people.
Mr. Freeman.
My thanks to the court.
All right. You're all set. Mr. Jackson. Thank
you.
You too.
All right. Did we find Mr. Kane?
I don't know where Mr. Kane is. but he's not where he's supposed to be.
They may have taken this.
Right. Starvation is just over. Behind me. It real well, like I was when a kid watch. And my braid my hair and sings. That's all I didn't know that. I ain't mad.
People to hear me.
I should just watch it. Since he was 9 years old. Up at that level, you know that. I was excited, that's all. Big situation, why the student took in Norman Hill, my mother was a Catholic school, but she couldn't read. Yo, what is it?
To us. All right. So, Miss James, you are with Mr. Jackson, is that correct?
That is correct.
All right, let's call that file. We're on the record in docket 25-030-03019. That is People, the State of Michigan versus Benjamin Jackson. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Miss James.
Good morning, Your Honor. Gidget James on behalf of Benjamin Jackson. He is Zooming with me from our office. He's seated to my left.
All right, thank you. And sir, you are Benjamin Jackson, is that correct?
Yes, Your Honor.
All right, and you can hear me all right, Mr. Jackson?
You can.
All right, thank you. This is the time set for a probable cause conference. Miss Fortuna Gill, how are we proceeding?
I will defer to Miss James.
Miss James.
Your Honor, we are leaving this set for the exam next week.
Okay, so we're gonna leave on for prelim for October 20, as previously scheduled, October 24th at 9:30. That'll be live in person on the 6th floor of City Hall of Lansing. Anything else for the record in docket 25-03019, Ms. Fortuna Gill?
Not for the people.
Anything else, Ms. James?
Nothing further, Your Honor. Thank you.
All right, thank you. We'll see everybody on October 24th at 9:30. Thank you for your appearance today.
Thank you.
Your Honor, the only case left on our docket, that
That's the. Where my luxury? No. Hey, hey, can I have any type of lunch?
Yeah.
All right. All right. All right, I'm just waiting, so. All right. Take my life watch. Are we having out of body experiences from sleeping on my left side? Yes, shit. All the time. Out of the body experiences from sleeping on my left side. I've been having take it low. Shit's hell. I've just been observing. Shit. The World Trade Center up too. What's going on? That's how cool it is. It is.
Post 2.
That'll be next.
Is that next?
My guy next, yes.
All right, because post 2 is coming up the works a little bit. All right, so this is Mr. Centeno. All right, so we're on the record in docket 22-01240 and 24-02906. That is people of the state of Michigan versus Enrique Centeno. This is Judge Flores docket. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Goodrich.
Attorney Luke Goodrich from the Public Defender's Office, here to represent Mr. Centeno on both of these files.
And sir, you are Enrico Centeno, is that correct?
Enrique Centeno. Yes.
Thank you. This is the time set for a forensic review. I think the defendant was found incompetent and we were awaiting an order of awaiting the competency report. Is that your understanding, Ms. Fortuna Gill?
Yes, Your Honor.
I think I signed that on, signed the last orders.
Your Honor, I believe the original finding was goes back to May. The court has a couple times gotten word back from that he's still not competent but restorable. It is my understanding that a month ago, the court had a hearing here.
Right.
And basically said due to the extensive length, if he still has not been found to be competent by this court date, that the court would likely dismiss the files at that matter at this time.
But let's see, this is for, I have an A and B that's following the flee and elude fourth. Is that a fair statement? The second, one is an assault and battery and one is a flee and elude force.
That is correct, Your Honor.
And I think I signed the order, the original order.
The original order.
Let's see when I signed it. Because that's, you've got, it's my understanding, it's about a year from that date.
So, Your Honor, if I may, we request, the court signed the order for competency evaluation.
On December 17th?
I have January 7th of 25. And then Mr. Sentinels had some health issues that caused the initial evaluation to be rescheduled one time because he was in the hospital for a week with an infected hand. And then the official order that he was not competent but restorable was entered on May 20th, I believe. And then we have since had reviews on July 25th and September 11th. He was found to be still in basically the same exact position at that time. He has not been taken to the forensic center.
I have the order for competency examination signed on December 17th, 2024.
Okay.
But we didn't have a report.
Sorry, I was looking at the other files, dates.
So that's on 24/029/06. That's the packet. And I signed that on December 17th, 2024. And then received a letter from evaluation. That looks like it was February 14th. Received another letter on March 13th. Another letter on April 1st. No, I'm sorry, March 17th. I'm sorry about that. That's March 7th, dated March 17th. Then I found that he was just incompetent to stand trial but restorable on May 20th. So is it a year from that May 20th date?
It would be under the law because this is a 2-year felony that he's charged with.
Right.
It would be 1/3 of that. So the court would have 8 months officially from that date. Right. We're already at 5 months and he still hasn't been contacted to go in and be evaluated to receive some type of residential treatment.
Right, because we have no competency review. And then we had a follow-up in September. So what's the full date for the prosecutor's office to make a decision on the case? It would be 8 months from
That May date.
That May date.
It would be January 20th.
January 20th.
So let's set this for review on, was that first week of January? I want to give time for the prosecutor's office to meet, and they'll decide what to do on it. Because that's one of two decisions. They have to make him a person required treatment under the civil code or dismiss.
I can put it on a statute, David.
No, we don't want it on a statute date.
Unfortunately, that first week is.
We got a lot to play with. We got a lot of room to play with. No, I mean, it doesn't matter what week we play. Okay? So stand by. So it could be December, it could be January. It's just to give it's to give enough time to figure out what to do on the file.
Understood, Your Honor.
But you've got, I think there's Christmas involved and then probably January involved. So I want a decision to be made on that date. not coming back and then we don't know what to do on it.
Absolutely. Your
So
Honor.
what do you, so I'll leave it in your hands. I think Mr. Goodrich is correct. Okay. I think it's still January, sometime in January. And so sometime we could do it in December, just to do it the first week of December.
That's fine with me, Your Honor.
So when we have time on for prelims, it would be the first or second week of December, the third week of December.
Wait, how many months do they need in contact to do the test?
December 4th.
That's what he was talking about.
All right, let's do December 4th at 8:30.
Now what's the next step?
And we'll set that for the review. And then
It don't matter. I ain't going to be on it.
so you can decide, Ms. Fortuna Gill, you can take it to the powers that be and they can decide what they're doing on the file. We've set for review hearing. If we don't have an answer, we'll treat it as the date for December 4th at 8:30. This is on the flee and elude, which is the felony 24-02906. We've just been placing because the packet didn't have the A and B that's been associated with it. And that was I think that I want to see when that was charged.
The A and B, Your Honor?
Yeah. Looks like it was charged in 2022.
It's been running under the same time frame because
Yeah.
I don't believe it had been addressed prior to getting picked up on this case. So I think
Alright.
they've been kind of on
That is-
parallel tracks.
All
That
right.
is correct.
All right. So I'm just going to put the same date for the A and B. December 4th at 8:30 and December 4th at 8:30 for an answer on Mr. Centeno. And that should put us almost 6 weeks in front of the deadline. Then I'll wait till you're. Okay.
Sounds good, Your Honor.
All right. Any questions concerning 22-01-240 or 24-02906, Mr. Goodrich?
No, Your Honor.
All right. We will see. So we'll have an answer how we're going to treat these files on December 4th.
Okay, thank you.
Thank you.
Thank you.
On December 4th. Okay. So it's on there. Oh, this
Yeah, no answer is a good answer on that, I guess, for our, or it places you in a position where you have to make a decision.
That's okay.
Okay. All right, Mr. Goodrich, do you have any more files in front of
For
today?
Rodney Terry, who was in post 2, visit 5. Your Honor.
All right. That's your case, Mrs. Kachukas, Ms. Kachukas. All right. We have sometimes place that is, you know, that was more,
January, I was like, we don't have any.
well, I mean, we could be, it's probably better off to get it way done before than just to get an answer on that because there. Have you heard from the complaining victim on the assault and battery on that?
We have had contact with the complaining victim.
All right. So we're on the record in docket 25-03027. That is people of the state of Michigan versus Rodney Terry. Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the people.
Mr. Goodrich.
Luke Goodrich from the Public Defender's Office, here to represent Mr. Terry, who's appearing over Polycom from the Ingham County Jail.
All right. And this is Judge Ward's docket. And sir, you are Rodney Terry, is that correct?
Yes, Your Honor, I'm Rodney Terry.
All right, thank you. All right, thank you. This is the time set for a probable cause conference. Ms. Kachukas, how are we proceeding, or would you like to defer to Mr. Goodrich?
Your Honor, it's my understanding that this is going to be left for preliminary exam. The people have extended an offer whereby Mr. Terry may waive his preliminary exam to preserve an offer to plead to one count of R&O with dismissal of the habitual third offender notice and dismissal of the second count of R&O.
And is that a fair statement, Mr. Goodrich? We're leaving this on with the offer the offer has been extended.
That is correct, Your Honor.
So we'll leave on for preliminary examination in front of Judge Ward on October 24th at 9 a.m. The offer's been placed on the record, and that'll be in front of Judge Ward. Anything else for the record in 2503027, Ms. Kachukas?
Not from the people, Your Honor.
Mr. Goodrich?
No, Your Honor, thank you.
All right, Mr. Terry, you'll be in front of Judge Ward on October 24th at 9 o'clock. Thank you for your appearance today.
Thank you, Your Honor.
Thank you, Mr. Goodrich.
Thank you, Mr.
All right. I'm gonna mute that room. Mr. Lopez, you can unmute. Jimmy Lopez. What day was he denied?
I emailed them.
Yeah.
I don't know, because Shelley's not here.
All right. So we are on the record in 2503001. That is people of the state of Michigan versus Jimmy Lopez. Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the people.
And sir, you are Jimmy Isaiah Lopez, is that correct?
Yes, Your Honor.
All right, thank you. This is the time set for probable cause conference. It's come to my attention that Mr. Lopez, you've made application to the public defender's office, is that correct?
I'm sorry, what you say?
Have you made application to the public defender's office concerning this file? Have you applied for a public defender?
Yeah.
All right, my understanding is you were denied.
So Judge, if I could, just very briefly.
Absolutely, Mr. Palmer.
Robert Palmer of the Public Defender's Office, not on behalf of Mr. Lopez, to be clear. He did originally make application for court-appointed counsel at the time of his arraignment. He was originally denied as not being indigent. In other words, he made too much money. It appears from what I can tell that our office did try to contact him and left him at least one, and it looks like maybe a couple of different voicemails at the telephone number that he provided at arraignment in an effort to rescreen him regarding his indigency. At least according to the notes that are in this file, the contact made by my office was never returned. They never received a return phone call. And so ultimately our office just closed out the file with the idea that, okay, well, he must be finding his own counsel.
All right, so Mr. Lopez, right now you've been denied application. Your application to the public defender's office has been denied. You would have to contact the public defender's office if you want to reapply with different numbers, I would think.
That's correct.
Yeah, but for our probable cause conference purposes, we're just going to leave it on or retain your own counsel. That's all. You can always retain your own counsel. I would suggest you don't have a preliminary examination where you represent yourself. That's probably a bad idea. But we'll leave on for preliminary examination in front of Judge Ward, and you can address some of these issues. All right, sir?
Yes, Your Honor.
So you should either make another application to the public defender's office to be screened for different numbers, or you should get your own counsel, all right?
Yes, Your Honor.
All right. I'm gonna leave this on for preliminary examination for October 24th at 8:30. So, Mr. Lopez, that is live in person on the 6th floor of City Hall of Lansing, and that'll be in front of Judge Ward. All right, sir?
Yes, Your Honor.
All right. Ms. Kachukas, you have October 24th at 8:30. Is that correct?
I believe so. I don't have that physically on me, but I will make sure.
All right. Anything else for the record in 25-03-001, Ms. Kachukas?
I just do want to verify, is witnesses do still need to be there for that date, correct?
I would treat it as, until you hear differently, or I would contact Judge Ward to see if an appearance is filed.
Okay.
Because you may not call I wouldn't call witnesses if appearance hasn't been filed yet.
I will.
But I don't.
When we get closer.
Yeah, but yeah, when we get closer. All right, Mr. Lopez, you have that date on October 24th at 8:30. You should either retain an attorney or make a second application to the public defender's office. All right.
Yes, Your Honor.
You should be all set, Mr. Lopez. Thank you for your appearance today.
Thank you.
Thank you, Mr. Palmer, for that clarification. Do you want to call anybody else? You want to call? We have Mr. Palmer. We could steal him on Childress.
Go ahead and handle Childress.
I know where Mr. Palmer is.
Yes, yes.
Vern Schaefer, he declined his CA.
Do we have Vern Schaefer here?
Should be in jail.
All right. All right, so we're on the record in docket 25-03-026. That is People of the State of Michigan versus Troy Childress. Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the people.
Mr. Palmer.
Thank you, Your Honor. Robert Palmer, the Public Defender's Office, on behalf of Troy Childress, the gentleman who stands to my right.
And sir, you are Troy Childress, is that correct?
Yes, sir.
Thank you. This is the time set for a probable cause conference. Ms. Kachukas, how are we proceeding?
Your Honor, I'm going to defer defense counsel on how we are proceeding. I will note that an offer has been extended of a plea to, I believe it was one count of armed robbery, or sorry, one count of retail fraud 3rd degree and one count of assault and battery.
Mr. Palmer. Is that a fair statement?
That is a fair statement. I'm going to be perfectly candid with the court. I completely forgot that she had made that offer to me because I hadn't had contact with Mr. Childress before this. So I think maybe if the court would allow me to, can I step in the hallway and talk to Mr. Childress?
You can talk to Mr. Childress, or we can leave on.
Let's do that. I'll leave it set for the preliminary exam. That's entirely my fault, Judge.
So we'll leave on for preliminary examination. That'll give you the opportunity to talk to Mr. Childress.
Absolutely. I can't believe I did that, but I absolutely did that. I completely forgot. She sent me an offer and Mr. Childress and I met for the first time about 5 minutes ago. So it wasn't like I had conveyed the offer. So.
All right. So let's leave on for preliminary examination for October 24th at 9 a.m. That'll give the opportunity for Mr. Palmer to talk to Mr. Childress. This will be in front of Judge Ward next week on October 24th at 9 a.m. Okay, sir? All right. Anything else for the record in 25-03-026, Ms. Kachukas?
Just that, Your Honor, I will reach out with Mr. Palmer when we get close to that date to determine if I can call witnesses.
All right,
absolutely.
Mr. Palmer.
Yeah,
all right.
Absolutely, Judge.
All right, Mr. Childress, you're all set. Thank you for your service today.
Mr. Palmer,
Yes, ma'am.
does your client want another notice for next week?
Sure, we'll take one.
Okay.
Yeah.
You were away before I could type that.
And then is there a Christian Burns Schaefer?
That should be Vern Schaefer is the last one.
All right, there's Mr. Burns Schaefer.
I'll be right up.
And does he have a lawyer?
I have no appearance and I have that he declined.
He declined public defender arraignment.
03014. All right, Mr. Burns Schaefer, I'll call your case. We're on the record in docket 25-03014. That is People of the State of Michigan versus Christian Burns Schaefer. Appearances for the record, Ms. Kachukas.
Thank you, Your Honor. Cassidy Kachukas for the people.
And sir, you are Christian Burns Schaefer, is that correct?
Can you hear me? Are you
Yes,
able
I
to hear
can.
me?
I can
Okay, I
hear
did
you.
not decline a public defender arraignment.
All right, so you are Christian Burns Schaefer, is that correct?
Yes, I am.
All right, and you can hear me all right, Mr. Burns Schaefer?
Yes, somewhat.
Okay, so today you are not represented by counsel, is that correct?
But here's so. I thought public defender, there was one at the meeting.
All right, you've been denied your application for the public defenders. Oh, he
Just to be
declined
clear,
it.
Judge,
He declined it.
Yeah, the notes that we have say that he was specifically asked at the time of arraignment whether he wanted to be represented by a public defender after arraignment, and he declined a counsel. He did not want the public defender's office to.
I also have retained attorney at arraignment. You're to retain your own attorney. Is that still an option, sir? Or did you want to make another application to the public defender's office?
I thought I had a public defender. I've been trying to contact them.
You only had one for arraignment. You did not have one for your preliminary examination. Did you want to make application to the public defender's office?
I would like to make an application.
Okay. All right, so I would think we would.
Judge, I can talk to him.
Okay.
I can jump on Zoom and talk to him. That's fine.
All right.
Thanks, Mr. Palmer. Save me an email.
Okay. So, they just shut the lights off at that.
Wave your hands.
Wave your hands.
There you go. Like the YMCA.
All right.
No.
All right.
He disappeared.
All right, Mr. Burns Schaefer, I'm going to place you in a breakout room. There's going to be somebody there from the public defender's office, and they'll talk to you. All right, sir?
Okay, thank you.
All right, they're not representing you at this time, but a public defender's indicated he'll meet with you. You may have to make financial application for representation from them. All right?
Okay. Yes, Your Honor.
All right. So let's leave that on, and then we'll let Palmer talk to him.
Yep, sounds good.
Okay. So we'll leave on for preliminary examination.
I'll go jump on Zoom.
All right. At 9 a.m. All right. So Mr. Burns Schaefer, I'm leaving this on for prelim in front of Judge Ward, and then we're going to put you in a room with the public defender's office. So it's left on for October 24th at 9 o'clock in front of Judge Ward, and then I'll place you in a breakout room with with somebody from the public defender's office, and you can go from there. All right, sir?
Yes, Your Honor.
All right, so you'll be in front of Judge Ward on October 24th at 9 a.m. And let's put you in your post 1-6. All right, let's put you in room 1, and then your public defender will be in there. Yeah.
And I think Brendan's coming out. That way I can help her.
Okay.
All right. I don't think I made you co-host. I admitted you. All right. So that was Burns Schaefer.
We're ready on Kelly. Ms.
Yep.
Schroeder's on Zoom.
All right. Zachary Kelly. I put him in room 1.
Okay.
So that's where Palmer to go. All right, so we're on the record in docket 25-01066. That is People of the State of Michigan versus Zachary Kelly. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
All right, and you are, and Ms. Schroeder.
Thank you, Your Honor. Assistant Public Defender Aaron Schroeder on behalf of Zachary Kelly. He appears by Polycom. I am here on Zoom.
All right. And sir, you are Zachary Kelly, is that correct?
Yes, Your Honor.
All right, thank you. And you can hear me all right, Mr. Kelly?
I can hear you perfectly clear.
All right, thank you. This is time set for a forensic review. And Ms. Fortuna Gill, how are we proceeding?
Your Honor, I'll defer to Ms. Schroeder.
Ms. Schroeder.
Thank you, Your Honor. We set this out because we did receive, and I believe the court did as well, a letter from the Center for Forensic Psychiatry back on September 30th of this year that indicated that they would hopefully have a report within the next 1 to 2 weeks to the court. To my knowledge, nothing has been received. I don't have anything in my files. I have not heard of anything from the pardon me. I have not heard from the prosecutor nor the court that they have received anything. So at this time, it appears we still do not have the report.
All right. It was I signed the order on the packet for August 14th, and then we're waiting a report from. I'm seeing if they, because I think they said they'd have one in the next couple of weeks, and then that's what Ms. Schroeder indicated.
Yes, I have a letter from them, a status report on competency to stand trial.
I'm just looking to see if we have also the same letter. All right, let's take a break and we'll see if we have the letter, because the letter's not in the file, and then we'll go back on the record in about 5 minutes.
Okay. I'm also here on Mr. Wildman. I know he's been waiting a while as well.
All right, well, we'll need the same court reporter for that.
I understand.
Yeah, we're just going to grab it we're just going to grab it so I can put it in the file.
All right, very good.
All right, so I'm in possession of the letter indicating this was on September 30th, 2025, that they would have a letter in 1 to 2 weeks. They obviously do not, because we're not in possession of the letter. It's to be completed by court order. They have 60 days to do this, and they thought they'd have it in the next couple of weeks. So we set it. I would think that at this time we're waiting for the report. We can set it another 2 weeks or 30 days, Ms. Schroeder.
I would say 30 days just to be safe.
Yeah.
When we get the report, obviously that if we get it sooner, it would speed things up.
Yeah, that's Ms. Fortuna Gill. Any objection to us sending it within 2 weeks within our schedule?
No objection, Your Honor.
Okay, we'll reset.
Did you say 2 weeks?
I thought we were doing a month, Your Honor.
30 days. We'll be 30 days. Yeah.
No objection to that either. I just wanted to give you the right date.
Reset for 30 days out for control for review.
November 20th at 8.
So we'll set it for November 20th at 8:30. And then if at that time we don't have a report done, then we can start addressing what options we have, what options are available to us. But we'll set it for November 20th at 8:30. Anything, and I am in possession of the letter written on September 30th. Anything else for the record in 25-01-066, Ms. Fortuna Gill?
No, Your Honor.
Ms. Schroeder?
Is it, I'm not, I'm kind of wondering if this is, did the court give him some type of a bond, or has it become no longer a bond? I'm looking at my file here. It doesn't look like it's. Oh, yes, I have it as bond denied is what I'm seeing now.
Yeah, I have. I think awaiting the report. It's fun. I think the magistrate remanded him on the 1 year.
Oh, I see. He was originally scheduled for sentencing, and then kind of last moment, we ended up sending him to forensic.
All right. So it's after sentencing,
But
after plea.
Yeah, but Magistrate Kelly must have saw his failing to appear for sentencing, and that's why she remanded him.
Okay. Let me set a bond in this matter. So I'll set bond in the matter of Ms. Schroeder. Would you like to be heard on bond? And I'll allow the people to also indicate, because I have a remand. This was remanded, and then he was set for sentencing, and that's when the packet was filed, and then the signature on the packet. So Ms. Schroeder, did you want to be heard on bond?
Just briefly, Your Honor. Mr. Kelly has been in custody for quite some time now. Yes, we do acknowledge it would be from a failure to appear, but some of that failure to appear, there was some question also as to that may have played that did play a part with regard to his our filing for the competency evaluation. I'd ask the court to set some type of low bond or some type of PR bond at this time, as he has been in for some time, and we are still waiting on a report, and the length of time for the report is certainly not Mr. Kelly's fault. So I would ask the court to consider a low 10% or a PR bond at this time, as he has pled to a misdemeanor, and I would just consider that. Thank you.
So the defendant on April 25th pled to an attempt R&O. Ms. Fortuna Gill, did you want to be heard on bond in this matter? Ms. Fortuna Gill, did you want to be heard on bond in this matter?
No, Your Honor. The people leave it to the court's discretion.
All right. I'm going to set a bond on this because we are waiting the report, but it's been remanded. But so I'll set a bond at. Bond was originally set at 2,000 PR. I'm going to set it at 2,010%. All right, I've set a 2,010% bond on the matter. Anything else for the record in 25-01-066, Ms. Fortuna Gill?
Not on behalf of the people, Your Honor.
All right, Ms. Schroeder, anything else on the record? We've reset this for November 20th.
Nothing further. Thank you.
All right, Mr. Kelly, we've set this for November 20th at 8:30, and bond has been set at 2,010%. Thank you for your appearance today.
Yes, Your Honor. Thank you.
That's Kelly. Did you want to go to Wildman?
We can go on Wildman.
All right, Ms. Schroeder, while we have you here, let's call the next case. So we're on the record in docket 25-00156. That is People, the State of Michigan versus Darcy Wildman. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Ms. Schroeder.
Thank you. Assistant Public Defender Aaron Schroeder on behalf of Mr. Wildman, who appears from the Ingham County Jail. It's my understanding that we still have not had anything with regard to forensics meeting with him or getting him restored at this time. So I guess we're still waiting. Thank you.
All right. Thank you. And sir, you are Darcy Wildman. Is that correct?
All right,
Is that a yes? Is that a yes, sir? All right. Thank you. this is the time set for a forensic review hearing. Ms. Schroeder's indicated, and rightfully so, that the defendant has still been found incompetent, waiting for the competency review. We adjourned it to today's date. The last action I have on this, I have a incompetent stand trial report on September 2nd, and then on September 11th, I have remaining incompetent stand trial on September 2nd. And then on September 11th, defendant was still incompetent, so we're waiting on a new report. Is that your last report that you have, Ms. Fortuna Gill?
Yes, Your Honor.
All right. All right, and this is a defendant has not pled to anything, and this is a file 3 counts R&O with an habitual. Is that a fair statement?
Yes, Your Honor.
All
It's
right.
a HAB 3.
HAB 3. All right, so we will await the report of competency. You have 2/3. Well, we have a 2-year, so that would be January, February, March, April, May, June, July, August. But I signed, let me see when I signed the order. It was September, right?
Well,
I think I
that
just signed it.
I think it was signed. Hang on.
I
The
think the original
restorable
order was
signed March 10th. I've seen in here order on competency signed by Your Honor on March 6th, 2025.
okay. That sounds right.
That's what I have as well, Your Honor.
So March, April, May, June, July, August, September. We're right on it. We're coming up on it in November. So January, March, April, May, June, July. So it'd be, and we're in October. Let's see, March 6th. March, April, May, June, July, August, September, October, November. So let's set this for, this is going to be like the other one. Let's set it for November 1st. And that, because the prosecutor's office is going to have to make a decision whether, if we don't have a report, it's getting 8 months into it. And that means that Mr. Wildman will either be PRT'd or the case will be dismissed. Is that your understanding, Ms. Schroeder?
I, in full candor to the court, I think there's a possibility that the habitual offender notice may impact this, the timeline.
Oh, that might.
In
yeah.
full candor to the court,
Yeah, you're absolutely right. You're absolutely right. That would change because it's at least a 2-year would change into a 5-year or 15-year.
I believe it would go to 4. Because habitual third offense goes 2 times the maximum, I believe.
Yeah.
Twice the maximum sentence.
So it'd be 4 years.
Correct.
Yeah, it'd be that's a 2 habitual. Habitual 3 would be 5 years, depending on how many priors. But this is an habitual third with 2 priors.
That's correct.
Okay. So that's twice the maximum at 4 years. So 2/3 of 4 years would be over a year.
It would be, I believe it would be 16, Your Honor, but because 15 months or 2/3, whichever is lower, so it would actually be the 15 months, I believe.
All right, I think 15 months. I think that's correct. So 15 months to be determined.
So
By
one-third would
prosecutor's
be.
office. So let's set it. Let's set it out because that's over a year. But we might have the answer, but we should set it for control date before then. Do you have, Ms. Schroeder? Do you have any requests for when we're going to set the next control date? 30, 60 days?
Well, I believe he is coming up very soon because they're supposed to do, I think it's every 90 days, they're supposed to do a reevaluation. So he should
Right.
come up soon. So I would say if we could do sometime in December, pardon me, December.
Let's do, so give me a date in December and then we can reevaluate the case and see if they've actually done because we're at the mercy of when they're going to do this, the review date. So let's get a date in December to review this. All right. So we'll set for control date.
The devil.
For review for December 4th at
Oh, 9 o'clock, I'm sorry.
at 9 o'clock. All right, so we will set the review date for December 4th at 9 o'clock. We're waiting on the ability on the defendant to attain competency, and I've put 15 months as the determination from March of 2024. All right. Is that right? March of 2024?
No, it'd be 25, Your Honor.
25. For March of 2025. Anything else for the record in 25-00156, Ms. Fortuna Gill?
No, Your Honor.
Ms. Schroeder?
No, Your Honor, thank you.
All right. Mr. Wildman, we've reset this for December 4th at 9 o'clock. And hopefully we'll have a report from that by then. Thank you for your appearance today.
Whatever. Oh, wait till I
You're ready on Earl, Mr. Harris.
You'll reap what you sow.
Assistant Public Defender Sarah Donnelly on behalf of Ms. Earl, who's standing to my right, Your Honor.
All right. And ma'am, you are Treyana Earl, is that correct? Right, thank you. This is the time set for sentencing the matter. I don't have a pre-sentence report. It appears that the probation department is scheduled to meet with Ms. Earl on August 26th. She rescheduled to September 16th. On September 16th, she failed to appear. They attempted to make contact via phone. Restitution was requested. The defendant has warrants out of Ohio, Minnesota, and Alabama. And so we don't have a checklist or report done. Mr. Harris.
Yes, Your Honor. It seems that when Ms. Donnelly was getting coverage as she's out of the office, it seems this may have slipped through the cracks from my review and from speaking with Ms. Earl. It seems the failure to appear for the PSI appointment on 9/16 was because she was in custody in Genesee County at the time, up until, I believe, fairly recently. I'm standing in on behalf of Ms. Donnelly, so I was originally going to be planning to ask if the court would consider resetting sentencing and perhaps seeing if probation could, while resetting sentencing, to allow for Ms. Donnelly to be here, and also resetting sentencing to allow Ms. Earl to try and get in touch with probation or get the PSI done, as it seems like the failure to appear for that PSI date on 9/16 was not entirely of her own volition. it was because she simply was in custody. My understanding from Miss Earl is that by the time Miss Earl's mother was able to advise probation regarding that PSI being missed, probation advised Miss Earl's mother that at that point it was less than a month before her sentencing was scheduled, and it was too late to try and get a PSI done. I would request if the court would consider now that Miss Earl has been released from Genesee County, resetting sentencing both to allow Ms. Donnelly to be here and to allow that, perhaps allow that PSI to be done, Your Honor. Thank you.
Thank you. Ms. Earl, is there anything, Mr. Harris is filling in for Ms. Donnelly. I don't have anything to sense you because I don't have a pre-sentence report, okay?
I haven't talked to her either. I emailed her yesterday.
All right, so let's do this. I'm gonna remand you to the county jail, okay? And what you're gonna do is I'm gonna send probation down there and probation's to talk to you concerning a pre-sentence report. Once that's all taken care of, I'm gonna set bond and you can go bond on your way. All right.
I have to, for the pre-sentence that I was supposed to do, I have to.
You're gonna go to the county jail today. Okay.
How long do I have to be in there to?
Until you're I'm gonna set, the bond will be set. Bond is set on this matter. So 500 initially was set at a $500 PR bond.
Yeah, I never went to jail for this.
Yeah,
the Ohio stuff, I was in the county jail for it.
I just want you to get your pre-sentence done so we have something to sentence you on.
But I was in jail, so how could I get it done? I was heading to.
That's true, but the fact that you have all kinds, I've got
don't have any warrants
at least
either.
warrants out in Ohio, Minnesota, and Alabama per the pre-sentence, per the probation.
I just got out of jail in Ohio. That's the warrant that I had. I was held in Genesee County jail.
So I don't know where you're gonna be, ma'am.
Yeah, I don't have any warrants. So.
Okay, well, Mr. Hannah's gonna take you down and and the probation will come down and see you. And then once you're done with your pre-sentence, I'm gonna set bond at $500 PR, okay?
Okay,
all right.
PR bond?
PR bond at $500 once your pre-sentence is done, all right? So you're gonna be held in the Ingham County Jail, and probation's gonna go see you. They've gotta meet with you so we can get your sentencing done.
Okay, so when they meet with me, I have a PR bond.
After that meeting, after they do the report. All right, so.
Anytime, sir?
And we'll reset the sentencing. Yeah, reset the sentencing for
December 12th at 8:30.
December 12th at 8:30.
Next week.
What was the date, Your Honor? Apologies.
Well, December 12th at 8:30 is date for sentencing. And then probation will be down to see them as soon as they can. And it'll probably be, I would think we're Thursday, probably next week. Yeah.
This is Friday.
Yeah, this is Friday, definitely next week, definitely Monday or Tuesday or of next week. All right, so I've reset the sentencing for docket 2501921. I'm going to remand the defendant for pre-sentence and probation. And after that, we'll set bond at $500 PR. All right, that's all for the record in 2501921. I will see you on December 12th for the sentencing. All right, ma'am. Right, that was Ms. Earl.
You're good.
Mr. Harris, thank you for stepping in on that.
Yes, Your Honor, not a problem.
We can do Anderson.
He would need to be brought up. I can
Yeah.
try to catch Mr. Hannah heading downstairs.
That'd be wise. He doesn't have a radio, so I can't.
Yeah.
call him.
Other than that, everything else says.
Who's on Polycom?
Well, Mr. Etheridge is, I believe he has a.
No, but who's from the jail?
I honestly don't know off the top of my head.
I was asking Miss Fortuna Gill.
Oh, sorry, my apologies. If Mr. Etheridge is
Mr. Etheridge,
Here,
Ms.
we can
Patrick,
go on more.
we do have one person from the jail.
I don't know who's in jail right now.
From the Ingham Jail Post 1, could you identify yourself?
Jeremy Taylor.
Taylor. I don't
Jeremy
have.
Taylor.
Jeremy Taylor with anything pending for art board.
Sir, did you indicate your name's Jeremy Taylor?
Yes, sir.
He may be in there waiting for a different judge.
All right.
But we don't have him.
All right, so we don't have you on our docket. You might be waiting for Judge Buchanan. But
He doesn't have anything in there.
but yeah, you're not on our docket.
Okay.
Do you know who sir, do you know who you're supposed to see?
Sir, they just brought me up in here, so I don't know what's going on right now.
All right. Yeah, we'll let the jail know that you're in ours, but I think you're supposed to see another judge. They might take you there via Zoom, so stand by.
Okay.
Sir, are you Dario Taylor or Jeremy Taylor?
Jeremy Taylor.
You have to say your first name again.
Jeremy Taylor.
That sounded like
Jeremy.
Dario. Dario?
Yeah,
Well, I heard
Jeremy.
Oh, that's
Yeah, it's Jeremy.
Okay.
all right. I don't know where you're supposed to be, sir. We thought Dario Taylor was supposed to be in front of Judge Buchanan. So stand by. We're gonna work on your case.
Yes, sir.
All right, Miss Patrick. Oh, here. Let's admit her. She was here. All right, Miss Patrick, we can call your case. So we're on the record in docket 25-02982. That is People of the State of Michigan versus James Mackey. Appearances for the record, Miss Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
And ma'am, you are here to represent Mr. Mackey. Miss Patrick, you can announce your presence for the record.
Yes, Your Honor. Melissa Patrick on behalf of James Mackey, who is not present today.
All right. This is the time set for a probable cause conference. Ms. Fortuna Gill, how are we proceeding? Would you like to defer to Ms. Patrick? And Ms. Patrick, you can explain your client's absence today at the same time.
I'll defer to Ms. Patrick.
So, Ms. Patrick.
Yes, Your Honor. I received a phone call from Mr. Mackey yesterday afternoon, and evidently he's had some medical issues where he had to go to the emergency room and he was eventually checked into the hospital. It's Sparrow Hospital, but I think Sparrow has a new name now. I think it's the University of Michigan hospital now, but I verified this morning that he is a patient there. And he will be there until, according to him, he'll be there until at least Monday.
All right. So let's leave on for preliminary examination. that'll give time for Ms. Patrick to talk to Mr. Mackey, and we can readdress this at preliminary examination if need be. So, and I certainly am not going to bench warrant if he's got a medical conflict. So Ms. Fortuna Gill, we'll just leave on.
That sounds good, Your Honor.
Okay. So we'll leave on for preliminary examination.
I don't think,
for,
Your Honor, we didn't set one the last time we were here.
Yeah. Oh, you didn't set what we didn't. So
I'll set up the next one.
I think we adjourned for good cause for PCC for today. So let's, can you do next week?
Oh, they gotta get subpoenas out.
Yeah. You need 14 days for subpoenas.
Yes.
We have a good cause adjournment. We even have a better cause adjournment if he's got a medical conflict.
Let's do October 30th at 1:30.
All right. We'll set the prelim for October 30th at 1:30. And it's set for prelim. And that should give you some time to talk to Mr. Mackey and to get subpoenas all set up. Anything else for the record? So we've left on for preliminary examination on October 30th at 1:30.
Okay.
Anything else for the record in 2502982, Ms. Fortuna Gill?
No, Your Honor.
Ms. Patrick?
No, Your Honor. Thank you.
All right, you should be all set, Ms. Patrick. Thank you for your appearance today.
Have a good day.
We
You
do
too.
Morris, that's Mr. Etheridge's matter. He's also on Zoom.
Mr. Rich Morris?
Yes.
Lauren Morris. All right. All right, Mr. Etheridge, we'll call your case finally. So we're on the record in docket 2403800. That is People of the State of Michigan versus Lauren Morris. Appearances for the record, Ms. Fortuna Gill.
Haley Fortuna Gill on behalf of the people.
Mr. Etheridge.
Good afternoon, Your Honor. Attorney Derek Etheridge from the Office of the Public Defender on behalf of Mr. Morris. I'm appearing by video. Mr. Morris is not present. He's in the Ingham County Jail and he's still incompetent, so I'd waive his presence if the court would like.
All right, thank you. We can waive his presence. I have he was found incompetent for a report done October 10th, 2025, which would have been a week ago. Do you have that report, Ms. Fortuna Gill?
Your Honor, I do not have that report. However,
Yeah.
I do have that report. My apologies.
Your Honor,
I
that
do have that
appears
report.
that appears to be an updated report. His original competency hearing was held back on March 14th of 2025. There's been issues.
There is an
with
updated report from Ms. Krapko. From Flora Krapko, indicating that there's a substantial likelihood of regaining competence. Do you have that report, Mr. Etheridge?
I have the most recent report that the court forwarded me. Yes.
All right. All right. And so it appears the allotted time pursuant to statute is 12 months as of the writing of this report.
And I disagree with that, Your Honor.
All right. And so do you disagree with the report or do you disagree with the time frame?
The time frame, Your Honor.
Okay.
There's less than 12 months to restore based on other issues in the case and the dating of the order originally.
All right.
At last hearing, we agreed that the date, the drop dead date for competency would be June 14th of 26, which is 7 months and 28 days from today's date, not 12 months.
So June of 2026 was what was the last date we talked about?
Your Honor, I can lay out the timeline for you.
Okay.
On March 14th of 2025, we had a competency hearing. We stipulated to the report finding him incompetent but restorable. This is the controlling date. For some reason, the proposed order that was submitted was not signed or filed at that time. On around July 25th of 25, order was finally signed saying that he was incompetent but restorable. On or around September 19th of 25, I had filed a stipend order with the prosecutor, Miss Gabby Estelle, who signed it, correcting the date of the order to March 14th, 2025. That amended order was submitted and signed on that date. I submitted a proposed order to correct the date of the order on that date, and I thought the court would sign it for March 14th, 2025 as an amended order correcting the date, but the court signed it for 9/19/25 and said it would not backdate the order. At that hearing on September 19th of 2025, on the stipend order, the court signed the March 14th date as the controlling date, or circled that as the controlling date. And at that time, we calculated the statutory period ending on 6/14 of 26. Now, I don't know what order the CFP is using. It appears they're using the July order when they should be using the March 14th date, but there's less than 12 months to restore. So I agree with the findings that he's incompetent and possibly restorable, but I don't know if he's restorable within the 12 months they think they have.
No, I think I would go with the March 14th date, which would have been the date, should have been the date of the original order. Is that correct?
Yes, Your Honor.
So that's June 16th. So we have June 16th of 2026. I'll write that.
June 14th, Your Honor, 26.
June 14th. Okay.
Although
June
I think
14th.
that falls on a Saturday or Sunday, I think, but that's the date.
All right. To find competence. All right. So yeah, I would agree that we're looking at a June of 2026 date. So Mr. Etheridge, so we'll let the Center for Forensic Evaluation know that that's the time frame. They have till June of 2026. But do you have a preference as to the review date? How we should? I'd say 30, 60, or 90 days till then for review date, just to see where we stand.
Yes, Your Honor. There was we've had an update saying it's going to be months before they can even get a hospital bed for him to even attempt to get him restored. So 60 to 90 days would probably be the best bet. We do have a current date set for 11/14 at 8:30. I think that should probably be reset or canceled and then set a new date 60 to 90 days out.
All right. And I have an order of competency on this one. I can sign it for today's date, but that's based on the new report.
Yes.
All right. So I'm going to indicate the defendant is still incompetent to stand trial, but restorable as indicated in the report. And I'll sign that of today's date, which is 10/17/2025. I'm going to indicate on the order that restorability is to be, we'll say June of 2026, which would confirm the March date that we've been talking about. That's what we're using as the March 14th date. Is that correct, Mr. Etheridge?
Yes, Your Honor. March 14th of 2025 is the control date.
All right, and we'll set it. So I'll sign that, make it a part of the court, and then let's set it. I think probably Mr. Etheridge is right, 60 to 90 days out.
I agree, Your Honor.
Yeah.
I was thinking 90
Just
days.
hoping for a bed to appear. We will contact the Center for Forensic Evaluation, indicating that the restorability date that we're using is June of 2026 in this matter. That's when the March order should have been signed. And so we'll use that date. And then we'll set for control date 90 days out. We're in that vicinity.
I'm gonna do 60 because we don't have 90. So more like 75.
75 is fine.
December 18th at 8.
All right, we'll do December 18th at 8:30. That should give us 75 days or in that vicinity. And then at least we'll know if they need a little nudge to get a bed ready. Or if there's already, if Mr. Morris is already in a bed, I highly doubt it, but we can wish. Anything else for the record? So we've set the control date for December 18th at 8:30. We're using the June date as a restorability date. Anything else for the record in 2403800? Ms. Fortuna Gill.
No, Your Honor.
Mr. Etheridge.
No, Your Honor, thank you.
Okay, you're all set, Mr. Etheridge. Thank you for your appearance today.
Thank you, Your Honor. Have a great weekend.
You too.
And it was not supposed to see today or something like that. What's wrong with it? They were saying that they was not supposed to see me today or something. I don't know what's going on, but the judge trying to figure it out. But they said they was gonna contact y'all and. Okay. You said all that.